My lord, I am actually seeking an indulgence. My lord, my matter relating 87-101. That is, everything was done. Hearing was made, and my lord, it was scheduled to be fixed on such and such date, and it would be reflected from the order itself. 87-101. What I am on, my lord, I am begging, actually, my lord, that is not. Actually, we cannot reside that in a dilapidated condition. Tagging is their heritage. No, that my lord, I will explain when my lord will hear the matter. I will just give me just 15 minutes time, and Mr. Mr. Sir is other side representing Kolkata Municipality heritage tag. Regarding, I am challenging that inclusion of my building is absolutely a void one, because you did not follow such and such provisions in the Act. And it is an admitted, and it is I am supported by the Honorable Coordinate Bench and Honorable Division Bench. Only just give me, my kindly, I am beseeching to that. Otherwise, my lord, rainy season already done, my lord. I cannot, because we cannot reside. That is the thing, my lord. I am
next week.
Mention
Next week, Monday.
Monday I will mention. All right, my lord. That liberty I have.
In your mentioning slip, put the reasons. I'll have a look at it. If I find there's reason enough,
Yes, I am taking that risk.
I'll see it.
I am taking that risk, my lord. I have a point. I can convince my lord.
We'll see that.
Then, my lord, I will mention, my lord, on Monday.
I come before your lordship.
That is the advantage. That is sufficient.
Lord, I come before your lordship with compelling circumstances, my lord, seeking leave to file a urgent motion, my lord, which has to be moved by Monday, because my lord, the order of demolition has been passed against the promoter without making the residents as a party. And now, my lord, it's the G+5 building where, my lord, all the residents are residing, my lord. Lord, may I?
Monday,
My lord, may I just?
it, give it with your.
But in the lordship kindly grants me leave so that, my lord, I can serve.
No leave right now. Come on Monday.
Well, Monday is the date. My lord, this is the 5th. My lord, kindly have a look at the order. 5th is the date of the implementation.
Go before the tribunal. Go before the tribunal.
I am not a party to the proceedings.
That's all right. Go before the tribunal.
Tribunal, my lord, I cannot.
Any
because
member, any person.
Because I cannot go to the tribunal because
You can.
No, my lord, in the Howrah Municipal Corporation Act, my lord, there is no scope for tribunal. If tribunal is not constituted, only writ jurisdiction. Otherwise, my lord, appeal would have been maintainable. If it was KMC, Calcutta Municipal Corporation,
on Monday we'll see.
No, Monday, my lord, would be difficult because Monday is the date on which, my lord, demolition is to be effected, my lord.
Monday.
Lordship grants me leave, my lord, I can serve and come back, my lord.
No demolition happens in one day.
My lord, it is given, my lord, kindly have a look at the order, my lord.
Doesn't do demolition for 4 years. Don't worry.
Kindly have a look at this order, my lord. I come with compelling.
I've seen many orders like this.
But
demolition doesn't take place in
given effect, my lord, my writ petition becomes infructuous, my lord.
See it on Monday.
Kindly grants me leave, my lord, so that I can move it on Monday, my lord.
Monday, sir. We'll see it on Monday.
On Monday, my lord, I have to serve, my lord. I have to file it and I have to serve, my lord. I shall serve by tomorrow, my lord. Everybody will be, my lord, service will be affected so that, my lord, everybody will be represented.
Before mentioning, have you given notice to Howrah Municipal Corporation?
My lord?
Before mentioning, have you given notice to Howrah Municipal Corporation?
Once your lordship grants leave, then only, my lord, I can file it and, my lord, a number will be assigned and I shall give a notice. It will be taken up as a motion on Monday, my lord. That notice.
You file it, we'll see it on Monday. First file it. We'll see it
then
on Monday.
I have to mention it on Monday, my lord.
Mention it on Monday.
Grateful to you.
Lordship, may I have your lordship kindly to mention a matter on urgent circumstances. Your lordship, a writ petition was filed challenging an order of demolition dated 21/10/2024. Your lordship, the notice was stayed. Your lordship. Subsequently, during the pendency of writ petition, a further notice was issued. Lordship, a can has been filed. Your lordship, the matter.
It has already been stayed. The demolition notice has been stayed.
Further notice has been issued, your lordship.
Further notice what? Show cause notice?
No, your lordship. For the demolition notice.
How can, for
kindly
one property, they'll have 2 demolition notice?
Kindly see, your lordship. I have filed a can application and it was to be listed today, your lordship, but the matter is not appearing in this list.
Demolition, when is the demolition fixed?
On 6th, your lordship, 6th May 2020.
Mention it on Monday. Mention on Monday. And in the mentioning slip, Put the reasons of
Lordship, I have prepared the mentioning slip.
Monday.
May I mention a matter, my lord, for upgradation
Upgradation next week onwards.
next week on? Very well.
I have your lordship's kind leave to mention, my lord, two appellate side matters, one of which was filed before your lordship, the other was assigned, released by my lord Justice Tirthankar Ghosh. It's an appellate side matter, item number 13 and 14, my lord. I am for the private respondent in one of them, and I am seeking to be added as a party in the other. My lord, what has happened is, after the release, my lord, it has been assigned to your lordship. It has been mentioned without giving notice to us in one of those writ petitions. It is appearing tomorrow, my lord. I am led by my senior who is not present tomorrow. If your lordship tomorrow, my lord, Friday, it may be taken up, my lord. Today, your lordship is taking the original side.
Right.
If tomorrow, my lord, item 13 and 14, there's a chance it's going to
How
be
do we
called.
know what is the item number tomorrow?
No, my lord, today
If-
it is at appellate side list. As of today, it's 13 and 14, my lord. Likely it will be taken up tomorrow is what I'm saying. My
Why?
lord, my
Appellate side is only taken today, Thursday. Matters are on Thursdays. That's it. Not tomorrow. Today's matter don't get
No,
spilled over to tomorrow.
appellate side matter, my lord.
Appellate side is only on Thursdays, sir. No, original side.
Original-
Today's original side.
Yes, my lord. Today's original side, my lord. Tomorrow,
How do you know tomorrow the matter will be 13 or 14? How do you know the list has not come out? How do you know?
we are just apprehensive that it may be taken up. My senior is not there. That is why.
We'll see that tomorrow. We'll take care of your apprehension tomorrow.
My lord, you permit to mention three matters, my lord, on identical issue for inclusion, my lord. My lord, I am.
Conclusion next week.
May I have your lordship's kind leave to file this application, my lord? My lord, in my land, the private respondents have been constructing unauthorized and illegal construction
Very
for
good.
now. Subsequently, my lord, we have made repeated representations, yet the corporation is not at all
Right.
considering. And my lord, if the construction right now it's almost complete. Now, if it is completed completely,
If
then
any illegal construction has come up on your land, it will be demolished in accordance with law.
yes, my lord. That may I?
Don't worry. Don't mention it.
And may I be permitted? My lord, the building infraction was there. There was a direction for demolition. Demolition taken place. Subsequently, in contempt court, my lord, the contempt court was kind enough to expand the order of the Honorable Writ Court. As a result of which, the municipal authority, my lord, under the threat of contempt, tomorrow fixed for further demolition.
Go to the contempt court, file a modification application.
Well, the time is, my lord,
Chakravarti, sorry.
deeply obliged.
Item number 34, Lordship. The petitioner do not want to proceed the matter, Lordship.
Doesn't want to
withdraw this
proceed.
matter. 34. No, appellate side. Lordship is the appellate side.
Take it.
Yes.
Call the list.
Original side matter, item number 1.
My lord, I appear for the petitioner. My lord, this has appeared at my instance for extension of interim order. My lord, this order was passed on 19th of March.
Just
Let
a
me-
minute, sir. Let me see the file.
Yes, my lord.
Opposition decision children. Opposition decision children.
Mr. Ghosh, you are appearing?
My lord, I have no,
For the KMC, you are appearing?
Yes, my lord.
What is the status? You have not filed your reply?
Status is, my lord, there, I understand from the department, my lord, the G plus 4 stories tanks,
Yeah.
building plan of sanction is an old building.
Yes.
Now, under the court's direction, the proceedings had been initiated in respect of the constructions on the upper floors.
Yes.
3 floors and also, my lord, one, my lord, the another, my lord, floor with a corrugated tin shed, my lord.
Yes.
And ultimately, the authority, the proceeding was initiated. Order has been passed, but so far as the ordering part is concerned, my lord, they are concerned about the top floors, my lord, where the corrugated shed is there.
Right.
That was directed to be demolished.
Right.
Now, well, at that juncture, my lord, they have approached this court. They are not the person responsible.
Right.
They say they are on certain capacities in occupation of that particular floor. There is a huge area because it's a building at Nikko House beside the High Court building. The Nikko House with the roof contents about 17,000 or 18,000 square foot. Therefore, the entire areas there. Therefore, that was directed to be demolished.
Right.
Now, he has come against that the actions by the authorities. for protection.
So you file your report, we'll decide this matter, we'll finish it off.
Not received any report, my
Well,
lord.
I'll stick very good.
You have taken time
এই report ছিল
on 19th March.
এর বলিস কেন? Well, a report has come, my lord. Of course, my lord, your lordship, my lord, the way you lordship asking me, my lord, that I'll file a different report has also come, my lord. In the, what I submit, my lord, that is my report, my lord, in my hand.
You file,
My lord, a copy may be provided to the petitioners also.
you give an advance copy. There was a direction to give a copy to the petitioner.
My lord, this thing,
Learned counsel for the respondent, Calcutta Municipal Corporation submits that he shall file. There was a direction to file a report by order dated 19th March 2025. Full stop. He seeks further time of 1 week to file his report. Full stop. Liberty is granted. Full stop. Advance copy of the said report shall be handed over to the petitioner. Full stop. In the meantime, there shall be the order of stay granted on 19th of March 2025
Is extended.
is extended for a period of 2 weeks. Let this matter be listed after 2 weeks. Mr. Ghosh will finish it off. There's
My lord, my lord.
Let kindly extend it for 3 weeks, my lord, because my lord, the report comes at the hearing, my lord, will be listed, my lord.
3 weeks.
Deeply obliged.
3 weeks. After 2 weeks, list the matter.
My lord has been pleased to extend the time to submit the report within a week.
In a week. We'll keep it after 2 weeks.
My lord.
After 10 days, we'll have the matter.
And the interim order is for 3 weeks, my lord.
Give a date. Give a date.
Kindly please.
This will be. Give a date, sir. Thursday hoga na? We'll have it on the 15th. No, we'll have it on the 22nd.
Yes, my lord. No difficulty. My lord. 15,
22nd, we'll have it.
22nd.
interim order.
I said.
The interim order is till 22nd only, my lord, in that event.
Because this is original site.
We can come back 22nd.
Yes, we'll have it on 22nd. Interim order is extended till 23rd of May.
Very well. I'm deeply obliged.
Item number 2.
Right. Milord, one of a kind matter again, Milord, has come before your lordship. Milord, a restoration application where Milord affidavits have been exchanged. Milord, my learned friend Milord is opposing the restoration application because Milord, she says,
File your reply.
Milord, reply, Milord, we have Milord served, Milord, may I file?
And an opposition was filed on the last instance.
The application is Milord otherwise within time, but Milord, my learned friend.
It's your restoration application.
My restoration application, Milord, my learned friend says, Milord, since this restoration application is at the instance of one of the multiple writ petitioners, so Milord, this is not maintainable. Milord, if had Milord all the writ petitioners joined him, Milord, to pray for restoration of the writ petition, then Milord, it would have been Milord maintainable. Otherwise, Milord, at the instance of one single petitioner, writ petitioner, this is not maintainable. This is Milord the point taken.
Yes.
Milord, possibly Milord argument on this restoration application would Milord require some time. I am Milord otherwise ready. But if Milord may make this prayer subject to, of course, my Lord's kind consideration, if my Lord kindly allows us to come back any day, Milord, after vacation. Milord, this may take some time. Milord.
Where is your reply, madam?
Reply, Milord, I have filed.
Application.
It's the application.
Oh, shit.
Like
Oh, I see.
Get affidavit. Affidavit in opposition.
Oh.
Affidavit replied to petition.
Third of May 2025.
আপনার নামটা
This is the only, show it to, this is not the one.
opposition is not there.
The reply to the application I'm talking about,
This is my reply,
this is your reply.
my reply
That's what I'm saying.
to her opposition.
No, where is your reply?
Well, that was on record. now.
Give a copy.
Record, but
Not
then
here.
my lord, I will.
Just give a
since
copy.
my lord, the prayer is for keeping it up.
Copy.
There is one more I'm sorry. না এখন জানতে পারছি আর একটা চেঞ্জ হচ্ছে সার্কামস্ট্যান্সেস
This is
I am
his
just
reply.
now told there is also a magnificent change in the
This is yours?
circumstances.
Audited.
When do you want it?
No. Just now, I am told by Mr. Singh. Mr. Singh is representing some of the other writ petitioners. I am just now told here that his clients also want to join me in the restoration application. So then an affidavit from their end is also what is required.
Because
Milord.
out of 8.
So you withdraw this application, you file a fresh application with all the other petitions.
Let them also take out a separate application. Both can be taken together. They are otherwise made pro forma respondent, so they can support by
When you
filing.
want to do it.
Yes,
When do you want?
very. Any day, after vacation, subject to my lord's kind convenience. Any day that suits your lordship. We'll see. We'll see.
12th of June.
12th of June.
12th of June.
So grateful, great, deeply
12th of June.
grateful.
At the request of the parties, let this matter be listed for hearing on 12th of June.
Would it be my lord's? Would it be also my lord's kind pleasure to record that I have put in my reply today?
Yes, affidavit, just take down one line. Affidavit in reply to the petitioner. Number 4. What is this? Affidavit in reply to
of
petitioner
the
number
writ petitioner
four to the
number 4. But I did not check the back sheet. I
Hey,
didn't.
please decipher this and tell me what should I. Affidavit in opposition has been filed by the petitioner.
No, this is affidavit in reply of the writ petitioner number 4 to their opposition to my restoration application. Affidavit in reply of the writ petitioner number 4 is filed.
Affidavit in reply to
Of the writ petitioner number 4 is filed.
petition number 4 is filed by the petitioner.
তোমাকে দেখা যায়নি দেখা যায়নি
You'll make sure that the bill goes.
He was not to be seen anywhere. The matter is over.
He always comes on time.
Late for his appearance.
How many of Mr. Banerjee will reply another Mr. Banerjee of legitimate.
Great.
Next.
Item number 3.
My lord, I appear for the petitioner. This is my lord, the issue is regarding the compulsion appointment is the second round of litigation. The authorities have my lord rejected the applications for my lord, the compulsion appointment. But I give you a short fact my lord, of this case and some of the records, and then I come to the impugn order. Well, my father was the assistant engineer of the Kolkata Municipal Corporation, working in the Chief Municipal Engineer Civil Department.
Yes.
He died on my lord 18th of June 2019.
Yes.
The petitioner before your lordship is the daughter of the deceased employee. My lord, the petitioner, my lord, the marriage tie of the petitioner, my lord, was dissolved, my lord, on 8th November 2017. And then she came to her parents' house, and my lord was my lord, dependent on father's family. This is family. My lord, thereafter, my lord, the application was made within the 6 months. 18 June 2019, father died, and the application was made in my lord, September. And initially, the consideration was made, if your lordship kindly looks at the sum of the documents, just hurriedly, I'm just placing it, and then your lordship will come to the. Well, this is my application at page 30, sorry.
Compassionate appointment you're seeking.
My lord,
Compassionate appointment.
compassion appointment. Dear my lord, the daughter, my lord, submit the application with the consent of the mother, and she said that I could be able, second paragraph, I could be able to look after my mother throughout her lifetime. Second paragraph, last line.
Yes.
And then long thereafter, it was, my lord, submitted in 2019 September. Long thereafter, in the month of April 2021, next page, the authorities required by certain documents. Well, I submitted, my lord, all the documents as required.
Yes.
Declaration of the widow deceased employee in connection with no claim job through affidavit shown before the first class magistrate. The requirement of the documents, my lord, you also can see the next document, the affidavit of my client regarding the release of the pensionary benefits. And then another affidavit at page 35 in connection with the prayer for providing appointment on compassionate ground. And the affidavit at page 39 of the mother, no objection if the appointment is given to the daughter. And 43 page, my lord, degree of divorce in the year 2017, 8 November 2017.
Yes.
But after that, my lord, the 1919 September, my lord, the application was made. They required the documents in April 2021. And at long last, my lord, in 2023, they, my lord, first, my lord, communication at page, my lord, 47. This is the first, my lord, rejection. They say, my lord, the apropos of the prayer 27 September 2019 seeking job under special regulation, she is hereby informed that such prayer has been rejected under clause 2B, ineligible. That ineligibility, my lord, they consider that because I was a married but divorced lady. But that was challenged before this court, my lord, because the issue of, my lord, the exclusion of the married daughter was considered in a special bench judgment of this honorable court, and that said that the adjective before the daughter that should not be there. Therefore, that judgment, my lord, said even the married daughter can also make an application, and more so, my lord, in this case, my lord, the daughter, my lord, herself applied that she will look after her mother, the widow of the deceased family, widow of the deceased family. Then the writ petition which was filed by me, my lord, that was, my lord, disposed of by an order at page 154. The writ petition which was filed, my lord, against the said order, simply by saying that ineligible, that was, my lord, challenged in a writ petition 2024. They say the petitioner sees compassion appointment. She happens to be a married daughter of a deceased employee of the Kolkata Municipal Corporation. The petitioner's prayer has been rejected by the authority on the ground of her marriage. The fact that the married daughter cannot be kept out of zone of consideration for providing compassion appointment has been set at rest by the larger bench of this court by the judgment delivered on September 13, 2017, FMA number 1277 of 2015. The same principle has been reiterated by the Honorable Division Bench of this court in the judgment dated 17 February 2023, passed in Mat 698 of 2020 with Can 1 of 2022, Payal Bhattacharya versus Kolkata Municipal Corporation and others. In view of the settled law, there is no scope to refuse consideration of application seeking compassion appointment on the ground of marriage of the daughter of a deceased employee. The impugned order dated 24th February 2023 and the decision taken by the Special Regulation Committee in its 127th meeting dated 20th November 2022 in respect of the petitioners is set aside. The corporation is directed to reconsider the prayer of the petitioner in the light of the judgment delivered in the matter of Purnima Das Supra and Payal Bhattacharya Supra after giving reasonable opportunity of hearing to the petitioner at the earliest, but possibly within 4 months from the date of communication. Now, my lord, the hearing was conducted by the additional municipal commissioner. And my lord, I submitted written submission giving details in support of my case at page, my lord, 57.
Yes.
You also kindly come to the written statement, written submission at page 60 towards bottom, second paragraph. Since the applicant was supposed to be given employment on compassionate ground immediately after the death of the father of the applicant on 18 June 2019, the KMC took about 4 years unnecessarily to reject the prayer of the applicant on flimsy ground initially. Since the purported reasons had been rejected by the special bench by delivering the judgment as far back as on 13 September 2017, the purported information sought to be required by the departmental personnel representing the KMC now cannot at all be relevant. And germane in view of the finding of the Honorable Appeal Court passed in the case of Payal Bhattacharya, the paragraph 29 of the said judgment is relevant for the instant purpose. It says interiorly as follows. If the applicant can establish that she was dependent on her father's income, as on the death of her father, the fact that she was married as on that date, or that she has been able to survive till date will not be the grounds for rejecting her claim for compassionate appointment. The judgment makes it clear that the prayer of the applicant for appointment compassionate ground needs to be considered on the basis of the circumstances that prevail as on the date of death of the employee concerned. It has all been stated that in the instant case, the death of the father of the applicant occurred on 18 June 2019, and that both the mother of the applicant and the applicant were fully dependent on the income of the deceased employee. Receiving the amount of pension by the wife of the deceased employee cannot be the relevant consideration for appointment on compassionate ground. The KMC itself knows the amount of pension being released in favor of the mother of the applicant. It also knows that whatever the amount being received by the applicant, mother now towards pension would be substantially reduced after the 2 years as a relevant rules. There is no reason to ask for the information of the present marital status of the applicant, since the applicant herself has already disclosed her present marital status in paragraph 15 of the writ petition, earlier writ petition. The long delay on the part of the KMC to take the decision on the claim of her compassionate appointment since 18 June 2019 being the date of death of the employee cannot stop the movement of the normal life of the applicant. Hence, the marriage of the applicant in the month of October 2022 cannot be the ground for consideration of the grant of compassionate appointment as paid for by the applicant on 27 September 2019. Had there been no delay on the part of the KMC to take the decision on the prayer of the applicants for job on compassionate ground, and had the applicant been given the job in 2020, there could not be any objection of the applicants being married in October 2022. Neither the marriage of the applicant in October 2022 nor the income of the spouse can be any consideration in this regard on the happenings as on the date of the death of the deceased employee. In any event, on the date of hearing of the case before the additional municipal commissioner, no order was passed requiring any such information, save and except that the department representing the KMC sought for such information verbally. In course of hearing on the scheduled date, in fact, no order was passed on that date, and no copy of any order was served upon the applicant. It is stated that the applicant, being the only child of her mother, in distress after the death of the only bread earner, the applicant was solely responsible for taking care of her ailing mother, and such responsibility still being continuing. The applicant is responsible to take care of her ailing mother, and the applicant is entitled to get the compassionate appointment as her mother gave her consent to provide a job to the applicant, being her only child. Number of this was my written notes of submission. Then, my lord, the hearing took place. Finally, the order, my lord, implement order as page 64.
So who got married? You got married
Well, after my in
in
22,
22?
initially 17, my lord, divorced.
Yes.
And I came back to my parents' house, my lord, in 2019.
Yes.
And 19, my lord, I was fully dependent. That application was made in 2017. Then they took, my lord, 4 years time, my lord, to communicate the rejection simply by ineligible. That man, I got married, my lord, to another gentleman in 2020, October 2022. That was, my lord, disclosed in my earlier writ petition when the court directed for consideration of my application. More so, my lord, it was the job for, my lord, looking after the family members of the deceased family. Now, my lord, the order which has been passed at page 64, you can come to, I'm not troubling you, lordship, because whatever my contention that has been spelled out, and thereafter, my lord, the case they say, and at page the reasons have been given, at page 65. Illogically come to, because in the calculation of the amount, the family, my lord, received, this is family as on the date of the date. That is the calculation, my lord. On the basis of that, my submission that the scheme, my lord, provides the case of the proves the case of the petitioner. And at page 65, illogically come to the reasonings.
Yes.
Roman 6, my lord, got it, my lord? Against such backdrop and proposition that the condition of immediate need for appointment has to be a paramount consideration, and if the said condition is unfulfilled, question of such satisfaction of other condition does not arise at all. It is found prudent to assess at first as to whether there is immediate need for appointment in favor of petitioner hearing. May I pause here for a moment? That immediate need has to be considered on the date of the employee. That is, my lord, already held by this court. Then I'll take your lordship the regulations, my lord, thereafter. As found on record, then before, my lord, placing it, my lord, I place the regulations first, my lord. Then, my lord, it will be easier to, my lord, consider that. You'll also come to, my lord, the regulation at page 51.
Yes.
Page 51, my lord, the regulations. Then I take your lordship, my lord, to that reasonings of the authorities.
Yes.
But that calculation which has been made to reject my case for appointment, that is, my lord, concerned, my lord, regulations 3, regulation of the scheme 3, which is at page, my lord, 52. It's a typed copy. Illogically, scheme 3.
Yes.
One of the conditions that needs to be fulfilled for offering appointment on compassionate ground is that the family of the deceased or prematurely retired employee is in need of immediate financial assistance. It is hereby clarified that the family of a deceased or prematurely retired employee shall be considered to be in need of immediate financial assistance if any of the two conditions mentioned below is satisfied. Therefore, two conditions are there. Any of the conditions is fulfilled, then it will be considered that the family is in need of the financial assistance.
Yes.
A, the family of the deceased prematurely retired employee will be considered to be in need of immediate financial assistance if the monthly income falls below 90% of the gross monthly salary of the employee before the death or premature retirement. This is one of the conditions. Well, I come within this clause A, because my client was one of the assistant engineer. He was one of the group A or B, group A and B category employees.
Yes.
The B is mean for the, as I understand, is for group C and D. Logically come to the monthly income of the family falls below the minimum salary of a category D employee in case of category D employees, or minimum salary of junior assistant in case of employees other than those belonging to category D. Be that as it may, these are the two the conditions. If one is fulfilled, then he will be considered that the family is considered to be in need of immediate financial assistance. So for my case is concerned that I come within the clause A. Now the next you also can see the gross monthly salary for the purpose of this definition shall mean basic pay along with DNS pay, DNS allowance, housing allowance and medical allowance. The monthly income of the family shall mean the aggregate of how it is to be calculated the monthly income on the date of death of the employee, total family pension per month, including basic DNS pension and relief, etc. And B, monthly interest income at the rate of 8% per annum on the total amount received by the family after the death of the employee or retirement of the incapacitated employee. Then he says, GPF not to be taken into consideration for the purpose of calculation of their income. But these are the conditions to calculate the income of the family on the date of death. But on that score, they have calculated the amount and they say that it crosses the limit of 90% of the gross salary of the employee. Now you will kindly come to the ordering portion, the reasonings and then the ordering portion. At page 65, which I was reading, my lord. Seven, at page 65.
Yes.
As found on record while drawing salary to the tune of rupees 75,132, father of the petitioner died in harness, leaving behind the petitioner and his wife and his wife as his legal heirs, family members. The petitioner claims herself as unemployed wife, and the wife of the deceased employee has been drawing family pension 35,378 at the material point of time. That was the pension my client, the widow, received, family pension. And at the time of consideration, they have recorded that 47,468 at the time of consideration. But I pause here again, my lord, that consideration at the time of consideration, if they take into consideration after 4, 5, 15 years, that would not be taken into consideration. Consideration to be made at the date of the death. Now, then it comes to, in addition, the family also received 11,14,367. But retail benefits, all everything. Then, 8% of the interest monthly to be taken into consideration to calculate the amount. And it is taken into calculation, then it comes to 7,000 per month. The calculation 8% interest. 8% of the total amount, if calculated, it comes to per month 7,429. It's an undisputed fact. Then if it is 35,370 is taken into consideration,
Yes.
and the 7,429, right, it is less than 90% of the gross monthly salary.
What about your husband's salary?
My lord?
What about your husband's salary later on?
My lord, my husband's, my lord, is a different family. My lord, his family, they wanted that what is the income of your husband in 2022. My lord, since my lord, the husband is a different family, belong to a different family, therefore, my lord, it is not required, even not covered under the scheme itself, as per the regulation, because he belongs to a different family.
Yes.
He is not one of the family members of the deceased employee. Now, they wanted to know that is the possibility that is the reason they have said. And then your lordship kindly come to in paragraph, my lord, the next page 66, 9. The relevant scheme, well settled propositional law and the record with regard to the case of the Payal Bhattacharya may not bar to assess the financial position in a family as it is on the date of consideration. It is not so much it is a court's direction that as on the date of the death. The relevant scheme of the corporation interior clarified that the family of the deceased employee will be considered in only need of financial assistance in case of either the monthly income of the family falls below 90% of the last gross monthly salary of the deceased employee, or the monthly income of the family falls below the minimum scale of the category D, category C employee. They are making a mistake, or well, it's not, it's a different group D and E employees implicated that covers the clause B of the scheme. As found on record in case of Payal Bhattacharya as an unemployed divorced lady who has to maintain her mother and minor child depending on pension of her mother, only both the conditions fulfilled in the instant case, 90% of the last gross salary of the father of the petitioner is found to be 67,619. And it appears some of the amounts monthly pension drawn by her mother, monthly interest accrued from the DCRB, salary drawn by her government employee spouse, what she denied to disclose may surely exceed the prescribed limit. But that is the only consideration that, but I cannot show to Lordship under the scheme itself, what are the amounts to be calculated? I don't know what was the component to be taken into consideration for the purpose of calculation of the amount. And I have shown it, my lord, in paragraph 27 of my writ petition, what the exact amount comes as on the date of the death, as on the date of the employee, at page paragraph 27. %90 comes to 67,119. And the less than 90%, 42,807. And the scheme, the process I have shown to your lordship right now, because this whatever the condition, it is to be applied in both the cases to me and also the employer. Therefore, I cannot go beyond this scheme, and they cannot also. Well, whatever the scheme has been framed by them, my right has come, my lord, for consideration because of the scheme. Well, I may marry the second time, my lord, in 2022, but it is the family of the deceased. My mother is there. I am to look after. That is the conditions, my lord, is there. My mother also said that I have no objection if the appointment is given to my daughter. Now, you logically come to that judgment of Payal Bhattacharya, who was directly considered at page, my lord, 67.
Yes.
The relevant part I am showing to lordship that at page 82, you logically come to page 82.
Yes.
Paragraph 27. The rule of exclusion of a married daughter having been declared constitutionally invalid, not having qualified to the test of a reasonable classification based on intelligible differentia, distinguishing those that are grouped together from those left out. The circular number such and such has no manner of application in the applicant's case so far as clause 2B, which was initially rejected of my case. The circular, my lord, which I am referring to, lordship, my lord. And this is the only circular pursuant to which 2B, my lord, my initial claim was, my initial case was rejected that I was ineligible. As a matter of fact, the status of the applicant has changed from that of a married daughter to that of a divorced daughter at the relevant point of time. Even that would also bear no relevance in view of the full bench judgment of the court mentioned earlier, by dint of which the word daughter has been dropped of any qualifying adjective thereto. The applicant has withstood the dependency test in view of no possible material being available to span the fact of the family of the deceased being unexpectedly put into extreme hardship financial distress, so much so that but for the appointment of the dependent on compassionate ground. The family member of the deceased employee may not survive. Dependency factor is based on a particular facts and circumstances of an individual case. Dependent is also a person who relies on another as a primary source of income after the death of the breadwinner of the family. A primary source of income is a sine qua non which would prevent a family from destitution and underwrite its substance. Compassion appointment is a form of state's guarantee to the family members of a deceased employee who died suddenly and untimely while in service under his policy of welfare the citizen to provide succor to a needy family, to support the family with a source of income to prevent vagrancy and disability is the motto. For all the practical purposes, the family of the deceased employee of the responsible corporation is devoid of any source of income to be self-contained and sufficient for the need of the sustenance of the family. Now, the paragraph 29, while I'm relying on, well, that is to be taken into consideration if the appellant can establish that she was dependent on her father's income as on the death of his father. The fact that she was married as on the date or that she has been able to survive till death will not be a ground for rejecting her claim for compassionate appointment. My faithful submission on the facts of this case, my lord, that on the date of my application before the authority, my lord, in 2019, admittedly, my lord, I was fully dependent on my parents' parents, because my father died in 19. The marriage was, I became a divorced lady, my lord, in 2017. I made an application. It was incumbent upon the authorities because it is the compassionate appointment, immediate need. Therefore, they had to consider it immediately. But they did not consider it immediately, although my application was before the authority at the right point of time. They took it to, my lord, to communicate as requiring certain documents in, my lord, 2021. 4th April, in the month of April 2021. I supplied the document. Even then, my lord, they did not, my lord, consider immediately either to accept my, lord, prayer or to reject my prayer. But therefore, my lord, I can wait. My learned friends are taking that what is the income of your spouse. I'm coming to the second question. The first question is, my lord, whether, my lord, because of the delay, the movement of the life of anyone regarding the marriage or something like that can be halted. Therefore, my lord, I got a marriage, right? And this fact was I admitted and stated in my earlier petition. And despite that, my lord, they contested the application, and then the court also directed that we consider because he has, my lord, withstood the dependency test, therefore his case to be considered. This is the first aspect of the matter. Because, my lord, that is to be considered as on the date of the death of the employee. Yes. Second, my lord, consideration is that the scheme does not say, or the rather scheme says that what is the components to be taken into consideration for the purpose of calculation of the amount of the pension, of the amount. That this is family on the date of death. What is the income? And on such consideration, it is to be considered whether he is the family is in need of the compensation appointment. Yeah. And here in this case, my lord, my lord, I consider that I got married, my lord, to a gentleman in 2020, October 2022. But my mother is there. My mother has given a consent. Therefore, I seek for the job to maintain the family of also the widow of the deceased employee. They cannot say that because you have married, that what is the income of your spouse, not being well incorporated in the scheme itself. And on that assumption, they cannot say that appointment cannot be granted.
Yes.
And you also can see,
anything else?
The court will initially directed me to submit a report. You can see the first order of the bench, my lord.
Yes.
On, my lord. My lord, got the order, my lord?
Yes.
The court directed to deal with the contents of the petition, more particularly in paragraph 27.
Yes.
The paragraph 27, I referred to that in terms of that clause 3A and the component to be taken into consideration, my income falls
Yes.
below of 90% of the gross monthly salary. Now, they submit a report. Well, you have seen one, but the important aspect, they have mixed up the two issues, A and B. Well, A, B is meant for the scheme for the group C and D. Therefore, they cannot say that the income must be below the income, the monthly income of the group C and D employee. That is what they are saying. Illogically come to paragraph 13, page 9 of the report of the KMC. They have given a calculation. Next page 10. These 47, you got it, Madam?
Yes.
These 47,468, the pension which they have calculated is on the date of consideration of the application, but not on the date of death of the employee, which is required to be considered. And also the courts order also like that. Now, they have considered, I took it, like 47,000. Then, my lord, monthly interest DCRB 8%, 7,429. It's the same, I'm not disputing about that. Then, if these are the two things to be added, if the two things are added, then even that comes to 54,897. That falls below 60,690. 90% of the gross monthly salary. And there, side by side, they also they are same 67, 690, 90%. Therefore, if these two, accepting that the spouse income, which is not covered by sufficient, and that too also not on the date of the death of the employee. 14 illogically come to paragraph 14. Moreover, the appointment on compensation account under the regulations if eligible can be made to category D or category C employee only. The monthly pension drawn by the widow as of now is more than the minimum salary drawn by category C or D employee of the corporation as stated above. The minimum salary of the junior assistant is rupees 29,000 only, and the pension that the widow is receiving is 47,700. Therefore, they are saying that the income must fall below the monthly salary of the group C and group D employee. But that is not the scheme. Illogically come to once again the scheme itself, because whether I come within the purview of the scheme, whether my client is entitled, that is not the only issue here, and the calculation of the amount. At page 52, you illogically come to at page 52. It says that one of the conditions that it needs to be fulfilled for offering appointment on the compensation ground is that the family of the deceased employee is in need of immediate financial assistance. Then it is hereby clarified that the family of the deceased or permanently retired employee shall be considered prematurely retired employee shall be considered to be in need of immediate financial assistance if any of the two conditions. Therefore, my case is that I come within the purview of A, small a, under paragraph 3. And they are referring to the B. The B is not covered by the position of my client because my client was assistant engineer. He was not a group D or C employee.
Yes.
Therefore, they have mixed up and they are contending to say that the income must follow. They then denying that the 90% of the gross monthly salary of the income of the before the death. And they have said far the pile voltage is concerned, my lord, I don't see, my lord, that consideration was made in the way they in the same fashion as of that way. That is also the pile voltage case was a group D employee. They took into consideration clause B.
Yes.
Therefore, the only considering my restful submission before the my restful submission, my lord, that the only consideration because the I know about the compensation appointment issue. Therefore, the consideration is well required to be made because the regulation of the scheme has been framed by the government, by the authority.
Yes.
Therefore, if my case comes within the purview of the scheme, then I shall get the appointment. If not, my lord, well, I have made an endeavor to your lordship because they have considered also this scheme, and they also consider the income of the deceased family. They, of course, took into consideration the time of consideration by my submission that it should be on the date of the employee. If in my lord date on the date of consideration, that taking into account the components of the income to be taken into account, that is also falls below the 90% of the gross monthly salary. In such a case, my lord, I am submitting to your lordship with this great respect that there is no other reasonings to reject my prayer. Therefore, if my succeed, my lord, on that score, and so far the spouse part is concerned, well, I submitting to your lordship, my lord, he belongs to a different family, and on the date of death, my lord, he was not there. Therefore, question of asking his income, my lord, does not arise. And somebody is asking for any information which is required to be given under the scheme,
Yes.
therefore they cannot ask me to provide that, my lord, the information to a particular authority, my lord.
Yes.
This is my thought.
Lord, please come to page 42. It is her case that she got a divorce decree in 2017. If your lordships please come to page 45. Page 45, which is the decree. Kindly, my lord, take the cause title. Your lordships will find she is describing herself as Srimati Shombrita Ganguly, has your lordship of that, Devnath, aged about 29 years, occupation, service. So, my lord, as on the date of divorce, this is court record, where, my lord, clearly spells out that, my lord, she was a service holder. Now, my lord, page 30. This is, my lord, the issue of 17. Page 30, my lord, post her father's death, she applied on 27th of September 2019. Now, my lord, your lordships will find here there was no disclosure about her income or the family's income. The gentleman, my lord, worked for a while. So, whatever investment he had, the income out of the investment, there is no disclosure. So, what happens is the corporation, my lord, writes a letter seeking information, which is at page 31. I'll just highlight, my lord, 2 or 3, my lord, clauses. Please come to clause 5.
Yes.
Monthly income certificate of both widow of ex-employee and the applicant.
Yes.
Because, my lord, we noticed that, my lord, she is a service holder. Then, my lord, marital status is there. There are other, my lord, declarations which are sought for. Now, my lord, the declarations that they gave, my lord, in the affidavit, both the mother and daughter, this aspect of the matter was completely silent. Your lordships will find the affidavit starting from page 32 to 41.
Yes.
These are all, my lord, certificates saying that mother saying no objection to the daughter's employment, If your lordships kindly takes the first affidavit, page 32.
Yes.
Lord, dear, kindly see paragraph 3, they declare that they are the heirs. And then paragraph 4, all financial benefit to the mother. Have no objection. If my mother will receive all financial benefit, there is no other legal heir claimant. I shall not claim any financial benefit. This is not the first affidavit. Kindly come to the second affidavit, page 35.
Yes.
This is also Lord, the same, to the same effect. Then Lord, 37 is the third affidavit.
That's mother.
Yes, that's the mother.
Yes.
Your lordships will find there is also no such declaration. Then Lord, page 39.
Yes.
Paragraph 6, she says that she has no objection if her daughter is employed.
Yes.
Lord, two important things, Lord, I request your lordship to kindly record that in these affidavits, there is no declaration that she was a dependent on her father as on the date of death of the father. And secondly, she does not disclose what happened to her service, which she declared as she declared that she was a service holder as on the date of death, date of the divorce. Sorry. Extremely sorry.
Yes.
Lord, unfortunately, the corporation, Lord, went in a different direction when they rejected her claim for the first time. Lord, if your lordship kindly sees the rejection, it is at page 47. Your lordships will find it says, apropos such and such seeking job, she is hereby informed that such prayer has been rejected under clause 2B of extant special regulation. Clause 2B alone. The other issues were not considered. Now, your lordships may kindly come to page 52 and kindly, my lord, see 51, sorry. It starts at page 51.
Yes.
Kindly, my lord, see the clause 2A starts, my lord, at page 51. 2B is, my lord, at page 52. It says, for the purpose of appointment on compassionate ground, a dependent of a corporation employee shall mean wife, husband, son, unmarried daughter of the employee, who is a solely dependent on the corporation employee. Lord, what was lost sight of is a special bench judgment of our High Court, where, Lord, the daughter, this additional, Lord, adjective unmarried daughter has been, Lord, taken off. But, Lord, one has to also look at that special bench judgment because, Lord, now this 2B stands read down by reason of that judgment. So, Lord, we have to also see the rationality of that judgment. So, Lord, I first take your lordships to that special bench judgment, which is reported in 2017, volume 4, Calcutta High Court Notes 362. That is, Lord, prior to Payal Bhattacharya. That's the first, Lord, special bench judgment. Lord, I'll make a copy, Lord, each time I come before your lordship, Lord.
That is Arpita Sarkar.
That is, no, this is Justice Matre, Justice Chakraborty, and Justice Dipankar Datta. That's the special bench judgment. It says Arpita Sarkar. Yes, your Lord, Arpita Sarkar. This is the judgment.
First name. First name Purnima Das. Second হচ্ছে
Oh, whatever. দাও এটা আমার বই হ্যাঁ 362 2017 volume 4 হ্যাঁ কি হলো 362 হ্যাঁ what happened এ কি আরে ভাই Lord, please take note of paragraph 89. এইটাতে নেই Please take note of paragraph 89. Lord, I'm really sorry, Lord, I'm little handicapped. If your lordship permits me, kindly take paragraph 89.
Yes.
Lord, this says that if married daughter is considered, the income of the spouse should also be considered.
Yes.
So, Lord, if today my learned friend, Lord, says that I can't rely on 2B, I say it is read down to the extent of, Lord, the judgment of the special bench. And, Lord, obviously, the income of the spouse will have to be taken into consideration apart from her own income.
Yes.
Because the first point is the dependency. Her income, her spouse's income. These are.
For that, he has an argument that the day when the application was put, she was not married.
She was not married. So, Lord, let us, Lord, forget about the income of the spouse. Let us concentrate on her own declaration in the court records. And your lordships would not find any consideration there. So, Lord, today, what happens is, both the learned single judge and division bench, they say that the finding or the rejection is set aside because it is dependent on 2B, which stands obviously modified by reason of the special bench judge.
Yes.
So, Lord, the matter goes back. And, Lord, the considerations, Lord, now, your lordships kindly see the considerations, Lord, from the impugned order,
Yes.
which is at page 64. Lord, please come to page 65, paragraph 5. First, Lord, Payal Bhattacharjee, how it has been considered by the authority. From record, it transpires that in terms of the judgment of the Honorable Appeal Court dated such and such, the case of Payal Bhattacharjee was reconsidered, assessing the following 2 points. A, as to whether the appellant was entirely dependent on his father at the time of his untimely death. B, as to whether she, along with family of her father, was in distressed condition and in need of immediate financial assistance. Upon such assessment, it was observed that she had reasonably succeeded to establish her claim of being entirely dependent on her father's, notwithstanding the fact the family of her father was in need of succor. Following the scheme of the corporation for appointment under death in harness ground, Payal Bhattacharjee was offered job. So, Lord, this is what Payal Bhattacharjee's case is. And this is, Lord, how it has been, Lord, dealt with. Then, kindly, Lord, come to paragraph 7. As found on record, while drawing salary to the tune of 75,000 and odd, the father of the petitioner died in harness, leaving behind the petitioner and his wife as his legal heirs, family members. The petitioner claims herself as unemployed and wife of the deceased employee has been drawing family pension of such and such at the time of consideration. In addition to the family also received so and so as death cum retirement benefit DCRB, excluding the amount from General Provident Fund. From point number 15 of the writ petition and submission, during the hearing, it has been learned that the petitioner got married to a government employee since October 2022. Despite requests to disclose earning of a spouse, it is contended that such income is not at all germane at this stage to provide employment, since the matter is to be considered on the basis of circumstances prevailing at the material point of time. Then, Lord, reasons are in paragraph 11. Your lordships may kindly take Roman 11. As found on record, in case of Payal Bhattacharjee, an unemployed divorced lady who has to maintain her mother and minor child, depending on the pension of her mother only. Both the conditions fulfilled. In the instant case, 90% of the last gross salary of the father of the petitioner is found to be 67,619. And it appears that some of the amount of monthly pension drawn by her mother, monthly interest accrued on DCRB, and the salary drawn by her government employee spouse, what she denied to disclose may surely exceed the prescribed limit. The monthly pension drawn by her mother itself is more than minimum salary of category D, category C employee. Now, my lord, kindly vis-a-vis this paragraph, please take the scheme now. Page 51.
Yes.
Lord, paragraph 1 of the scheme, because Lord, my contention would be that this is a scheme which has to be read as a whole.
Yes.
Now, Lord, paragraph 1, the municipal commissioner shall appoint a dependent of an employee of the corporation who dies in harness or retires prematurely on being declared permanently incapacitated for active service, leaving his or family in immediate need of assistance, to a post not requiring recommendation by the municipal service commissioner. So, my lord, this is the first condition, immediate need of assistance. Number 2, one of the dependent of the corporation who dies in harness, who retires prematurely on being declared permanently, may be offered appointment. The family of the deceased or the retired employee, as the case may be, is need of immediate assistance. Lord, kindly mark this. Then, please come to paragraph 3. One of the condition that needs to be fulfilled for offering appointment of compassionate ground is that the family of the deceased prematurely retired employee is in need of immediate financial assistance. Again, my lord, immediate financial assistance. It is hereby clarified that the family of a deceased prematurely retired employee shall be considered to be in need of immediate financial assistance if any of the two conditions mentioned below is satisfied. The family of the deceased prematurely retired employee will be considered to be in need of immediate financial assistance if the monthly income falls below 90% of the gross monthly salary of the employee before the death or premature retirement. The monthly income of the family falls below the minimum salary of category D employees in case of category D employees, or the minimum salary of the junior assistant in case of employee other than those belonging to category D. The gross monthly salary for the purpose of this definition shall mean basic pay along with dearness pay, dearness allowance, house rent, etc. The monthly income of the family shall mean aggregate of total family pension per month, basic dearness pension relief, monthly income at the rate of 8% on the total amount received by the family after death of the employee, retirement of the incapacitated employee. Since GPF accumulation is entirely out of the savings of the corporation employees during his period, the same shall not be reckoned for the purpose. Provided that where an ex-employee who had to incur medical expenses, this is not important. Then C, monthly income from movable and immovable properties, the family members are expected to submit a declaration on the matter. Now, Lord, I pause here for a moment. Lord, the gentleman worked, Lord, for a long period of time. His savings, his income, nothing is on record. Nothing is on record. Then, monthly income of the dependents of the ex-employee named in the application, the family members are expected to submit a declaration on the matter. That is the reason, Lord, I took your lordship through the affidavit to show none of these C and D is reflected. One can't stop at 3A. To mature, Lord, 3A, we have to, Lord, also go through the other clauses in the policy, because, Lord, it's a composite policy and it is has to be read together. Now, even in 4, Lord, your lordships may kindly take 4. The dependent of an employee seeking appointment on compassionate ground shall henceforth make an application in the prescribed pro forma within 6 months from the date of death of the deceased employee, etc. If no application is submitted within this period, it will be presumed that the family does not require immediate financial assistance. Lord, this is not material, but I am just saying that immediate financial assistance is the, Lord, the basic concept of any compassionate appointment scheme. Lord, what is the troubling factor here is this, that, Lord, the family has withstood the situation from 2019, 18 June 2019. Then there was a COVID period. And of course, Lord, the corporation also took its time to consider. But, Lord, even if we go back to the date of death of the employee, one can't shut its eyes to the fact that the family has survived for all these years. And the fact that the situations have also changed, apart from the situation which was prevailing at that time, the subsequent fact, we cannot just shut our eyes to the subsequent fact, because Lord, the fact that it has survived the immediate assistant period, that itself would show that the family is not in need. Lord, what is important here is this, that Lord, a criteria is prescribed. Because, Lord, when a gentleman dies in harness, he is normally, the family is in shock. The family is normally expected to have a percentage of his income, which is not the part of the scheme. But if he had retired, the family pension which the wife is retiring might have been increased, but Lord, he would have survived with the family pension.
Right.
Now, the issue is the untimely death. And also issue is that immediate Lord assistance. Lord, I just Lord want to refer to just one or two judgments of the Supreme Court, Lord, in this regard. Again, 1994. Lord, I'll make Lord copies and Lord I'll hand up Lord just relying on the book. By lunchtime Lord I'll.
Yes.
No, 94 4. Lord, first judgment is 1994 4 SCC 138. আমাকে বললেন আমি কালকে রাত্রে ওটা I could have made the copies.
Yes.
Lord, please take paragraph 225 and 6.
Paragraph
225 and 6. The question relates to consideration which should guide while giving appointment in public service on compassionate ground. It appears that there has been a good deal of obfuscation on the issue. As a rule, appointment in the public services should be made strictly on the basis of open invitation of applications and merit. No other mode of appointment nor any other consideration is permissible, neither in government nor the public authorities are at liberty to follow any other procedure or relax the qualifications laid down by the rules for the post. However, to this general rule, which is to be followed strictly in every case, there are some exceptions carved out in the interest of justice and to meet certain contingencies. One such exception is in the favor of dependents of an employee dying in harness and leaving his family in penury and without any means of livelihood. In such cases, out of pure humanitarian consideration, taking into consideration the fact that unless some source of livelihood is provided, the family would not be able to make both ends meet. A provision is made in the rules to provide gainful employment to one of the dependents of the deceased who may be eligible for such employment. The whole object of granting compassionate employment is thus to enable the family to tide over the sudden crisis. The object is not to give a member of such family a post, much less a post for post held by the deceased. What is furthermore mere death of an employee in harness does not entitle his family to such source of livelihood. The government or the public authority concerned has to examine the financial condition of the family of the deceased, and it is only if it is satisfied that but for the provision of employment, the family will not be able to meet the crisis, that a job is to be offered to the eligible member of the family. The posts in class 3-4 are the lowest post in non-manual and manual categories, and hence they alone can be offered on compassionate ground, the object being to relieve the family of the financial destitution and to help it get over the emergency. The provision of employment in such lowest post by making an exception to the rule is justifiable and valid, since it is not discriminatory. The favorable treatment given to such dependent of the deceased employee in such post has a rational nexus with the object sought to be achieved, namely relief against destitution. No other posts are expected or required to be given by the public authorities for the purpose. It must be remembered on this connection that as against the destitute family of the deceased, there are millions of other families which are equally, if not more, destitute. The exception to the rule made in favor of the family of the deceased employee is in consideration of the services rendered by him and the legitimate expectations and the change in the status and affairs of the family endangered by the erstwhile employment which is suddenly upturned. Unmindful of this legal position, some governments and public authorities have been offering compassionate appointment. That's not important. It is for those reasons, paragraph 4, that we have not been in a position to appreciate judgments of some of the high courts. These are not the other judgments. Then kindly, my lord, come to that quoted portion.
We are of the view.
Lordship kindly sees the quoted portion. We are of the view that extraordinary situations required extraordinary remedies. And it is open to the government in real hard cases to deviate from the letter and spirit of the instructions and to provide relief in cases where it is so warranted. To hold as a matter of law that the government cannot deviate any minute so and so. It would be ridiculous to expect that a dependent of a deceased class 1 employee should be offered appointment against class 3-4 posts. While we have leave it to the government to exercise its discretion judiciously in making appointment in class 1, class 2 posts or compassionate ground, yet a word of caution needs to be struck. It is to be noted that such appointment should be ordered in the interest rarest of rare cases and in every very exceptional circumstances. As a matter of fact, we would recommend that the government should frame a policy even for such appointment. Then, Lord, paragraph 5, it is obvious from the
Paragraph 6 is more relevant.
Now, my lord, this view has been consistently followed. And Lord, the later judgment says that it's a concession and not a right. Your lordships may kindly take note of this. 2008. No, 2000.
2000?
Oh, Lord, I very well, Lord, I come back to that. It is 2008, volume 15, SCC 560. But before that, Lord, I cite, Lord, another judgment.
Yes.
On the same issue, 2019, volume 3, SCC 653.
Yes.
Please come to paragraph 18 straight away.
While considering the rival submissions.
Yes, yes. The various judgments are quoted in paragraph 18 and 19. Kindly, my lord, paragraph 20, if your lordship kindly come.
Yes.
Reverting back to the question as to whether in a case of this nature, it was required to be pleaded and proved that death occurred in an accident, we must advert to the meaning of the term accident. This is not important. Then, if your lordships kindly come to the quoted portion.
As a rule of appointment.
Yes, yes. Then, Lord, paragraph 32 and 33, if your lordships, Lord, kindly. Oh, sorry. This is paragraph 32 and 33. This indigent circumstances, this is what is absolutely essential. Now, the indigent circumstances can be considered if not these materials come on record.
Yes. Yes.
So, my lord, the indigent circumstances is required, the onus is on the person who is applying to show that indigent circumstances. And in fact, I'll show from the division bench judgment, this onus was put on her. If we proceed on the basis that, Lord, a daughter is entitled to compassionate appointment, yes, she is, because of the special bench judgment which has read down the regulation. Then, Lord, she has to show that she is dependent on the family, dependent on the deceased. This is number one. And number two, what was the family income? This is just not the emoluments or the retirement benefit or the terminal benefits or whatever benefits that they have received, but also, Lord, whatever has been the income of the family. Because, Lord, the deceased employee must have had some income, movable, immovable, whatever. That needs to be disclosed. Now, Lord, the 2018 judgment, that your lordships kindly take one paragraph, paragraph 15. Page 560, paragraph 50. It is not a right, Lord, it's a concession. That is what it says. Paragraph 15, 15. Now, Lord, just to sum up, if your lordships kindly have a look at the division bench judgment. Of course, Lord, the division bench was considering this rejection on clause 2B. But, Lord, the division bench, Lord, laid down certain guidelines. Please come to page 84. Page 67, it starts. Please come to page 84, paragraph 29. Sorry. Says, if the appellant can establish that she was dependent on her father's income as on the date of death of her father. The fact that she was married as on the date or that she has been able to survive till date will not be ground for rejecting her claim compassionate appointment. So, Lord, division made it clear that onus is on her to establish that she was a dependent on her father. Lord, your lordships will find that is the reason why the impugned order records that she has not disclosed anything apart from the fact she says that I was a dependent.
Yes.
This is, Lord, the sole assertion that she has made. She has not relied on any document. She has not disclosed her income. She has not disclosed, Lord, what was the family's income, which is requirement of the scheme. So, Lord, in the teeth of this, Lord, I say that the rejection was justified. But these are my submissions.
Only one submission, but I submit with the, as I understand, on hearing my learned friend, that he is really, my lord, making out a third case, not in the impugned order. Because what the court is to consider that the reasoning which they have given justified the case of my learned friend or not. Because the lordship knows the case of Mahinder Singh Gill, that the petitioners, my lord, the respondent authorities cannot make out a different case when a challenge is thrown against an impugned order. Therefore, what we find here, I once again will take your lordship to take the trouble. What are the reasons they have given? They have given, my lord, basically come to page, my lord, 66. Clause 11. As found on record in case of Payal Bhattacharya, an unemployed divorced lady who has to maintain her mother and minor child, depending on pension of her mother only, both the conditions fulfilled. First of all, my lord, they have not disclosed the details of the decisions taken in case of Payal Bhattacharya. But what I understand, the Payal Bhattacharya case, my lord, the Group D employees, that covers the clause B of the regular scheme. Then it says, in the instant case, 90% of the last gross salary of the father of the petitioner is found to be 67,619. Then And it appears some of the amounts of monthly pension drawn by her mother, monthly interest accrued from DCRB. These two components I have disclosed. What is the amount as on the date of the employee, 35,000 odd, and 7,429 is the accrued interest on the detailed benefits. And then what they are requiring, salary drawn by her government employee spouse. But this is not the required under the scheme, required information. And I submit to your lordship that marriage took place in 2022. He was required to consider the situation as on 2019 when the application was made, or not on the date of the employee. Therefore, they have considered rightly upon taking into account these are the components. My learned friend has considered that different issues are there. But had it been in the reasonings, I could have make out that case. Now, what are the how to deal with those cases? The judgments which my learned friend is showing to your lordship, which are all those cases are general propositions of law delivered by the Supreme Court time and again. Therefore, we are not on that. We are on the issue that this is the scheme. You have framed the scheme. You have been asked to consider the issue by the direction of the Honorable Court. You took into consideration. These are your reasons for reject the claim. Therefore, whether that reasoning can sustain or not. Well, I have made an endeavor to show to your lordship that reasoning cannot sustain because that falls below 90% of the gross monthly salaries. They have not said that your salary, family, the poverty value, what is the income, all these things are not required. You did not consider it to be necessary. Therefore, your lordship, the judgment, I put it, your lordship time and again has seen the judgment of Mahendra Singh Gill. You can see the paragraph 8 only. Because it was time and again a placement before in different cases. The second paragraph 8, the second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds. Later brought out. We may here draw attention to the observations of Bose J. such and such. Public orders and publicly made in exercise of statutory authority cannot be construed in the light of the explanation subsequently given by the officers making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have the public effect and are intended to affect the acting and the conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Orders are not like old wine becoming better as they grow. Therefore, what is the order? That order is to be taken into consideration. Because my submission before lordship on the scheme itself on the calculation. It is entirely on the calculation based on the scheme. Therefore, my case, my lord, succeed, my lord. I have demonstrated to your lordship, my lord. What they are demonstrating, my lord, that is not justified. And the judgment was cited by my lord says general proposition, not, my lord, relations to this, my lord, particular issue before your lordship, my lord.
Heard both the parties. CV.
Much obliged.
Yes, Ms. Pyali Sen Gupta, give me the judgments.
By two, I
I'll just come back.
Item number 4.
Yes.
Your Lordship, I am on behalf of the petitioner. This is a matter of illegal construction. On the last date, the advocate of the KMC had sought time to file a report. It was verbally submitted that perhaps a demolition order may have been passed and maybe part of it has been demolished. Anyway, a report is sought for.
My lord, the demolition order was passed under section 400 subsection 8. Certain dates we are actually went there and demolished certain portion, and the demolition process is continuing, my lord.
Your Lordship, I am on instructions. I am not aware about any such and have not received any documents. If a copy of a report may be provided.
I am handing over.
Grateful.
So nothing survives in your present petition, sir.
I'm sorry, Your Lordship.
Nothing survives in the present petition.
If the entirety of it is been considered and order is for demolition of the entire premises, then nothing remains, Your Lordship. So far as the entire premise is concerned, as mentioned in the petition, it is to be demolished.
They will take action as per law.
Grateful.
Take down. What do you want? Now they are taking action.
Yes, definitely. I'm not.
I'm disposing it off.
Yes, definitely, Your Lordship. On the basis of this, I don't have anything further to add.
Take down. The petitioner has preferred the present writ petition alleging illegal and unauthorized construction at premises number 185 Picnic Garden Road, Police Station, Kasba. It is the case of the petitioner that he had entered into an sale agreement dated 11/12/2013, 2023, 11/12/2023, full stop, with the respond number 7 and 8, right?
Yes, Your Lordship.
With regard to
a shop room,
purchase of a shop measuring an area of about 500 square feet on the ground floor of Block A of the above mentioned premises for a sale consideration of rupees 6 lakhs, right?
Yes, Your Lordship.
Full stop. The private respondent demanded an additional amount of 4,80,000.
Yes.
Full stop. In order to make the said payment, the petitioner had applied for a loan, and at that stage the petitioner came to know that the construction of the said building is without any sanction plan. Full stop. Hence, the petitioner preferred several representations before the competent authority. Full stop. However, they failed to take any action against the private respondents who had raised the illegal and unauthorized construction. Full stop. Learned counsel for the municipality appears and hands over a report which is taken on record. Full stop. The report shows that the report reads that the work stop notice was issued on 18/2/2022. And further, the order of demolition under section 400 subclause 8 of the KMC Act has been passed. Full stop. It further reads that the demolition program partial demolition has already been taken on the said property. Full stop. In view of the said report, nothing, the petitioner states that he is satisfied with the said action taken by the respondent corporation and full stop. In view of the said report, since the corporation has already issued the order of demolition and partial demolition action has taken place, and the corporation assures this court that further demolition of the said property shall be carried out in accordance with law. Nothing survives in the present writ petition. The present writ petition is disposed of in terms of the report filed by the respondent.
Your Lordship, may I just pray that since the order is of 2022, if a timeline may be fixed for demolition, if at all possible from.
They'll do it for time.
In accordance with law that.
In accordance.
Grateful, Your Lordship.
Item number 5.
Lordship, in this matter being led by Senior Advocate Mr. Abdul Mr. Abdul Majumdar, please hear, my lord. We just start.
Given. The KMC has given.
Let me just start. We got it.
I've got the calculation.
You've got the calculation.
Yes. Okay, copy that. Get copy. AJ, can I ask the copy? Down.
Yes.
We have to go through this, my lord.
But
But we have also prepared a calculation.
I'll just indicate, Lord, let my learned friend take time. I'm not standing in the way. If your lordships plot fine, the page, your lordships will find this dues have fallen, it has fallen due from second quarter 2005.
Yes.
But that is not the period of dispute.
No. 90.
Let's see what he has to say.
Yes.
From 1996, according to their own admission and the division bench judgment, we are entitled to from 1996. Whatever payment we have received, that has been adjusted from 1996. This is what is due as of now, because the valuation and recovery was in issue in the earlier proceedings. From second quarter 2005 to fourth quarter 2010, this is the period of default.
2005 to 2010. So what about the amount that we entitled to refund? We went to claim refund. And then now they're raising this demand. We've already made payments. So we made
Where
payments.
is the outstanding? What is this?
So this has never been given to us. And so plus, so look at this. The date of the order. So this is the order. And so look at this. So we've given a chart of the payments we've made.
The assessment it is based on that old assessment. This is the period you have defaulted. You have paid for all the other periods. This is the period which is under.
So we've made the payments for these years, these periods that we've given. This is our payment subsequent. So the payments, our June period is 84 to 99.
Yes.
And so now, so they are asking for payments of 2005 onwards.
Yes.
But may I just indicate the period which is subject matter of dispute? And it is from 1984 first quarter to 1989. 99 fourth quarter. Subject to correction by Mr. Kaur.
On indulgence, Lordship. Mr. Shutrajit Talukdar appearing on behalf of the state Lordship. His mother has expired today, so I'm praying for 2 weeks' time. After 18, any day, my lord can give this.
He'll have it after 18.
But the only thing is,
if somebody is expired, I will not say.
No, I'm not asking, Lord. Of course, it has to be urgent. I'm just pointing out, Lord, I am giving my learned friend the calculation. Lord, his admission is at page 136, where he has made a representation to the municipality saying that he will pay from 27th of February 1996. Lordships may kindly come to page
My lord,
130.
only one submission, my lord. My lord, lordship may kindly bear with me for 1 minute.
Yes, yes.
My lord, if you
Just one. Kindly come to page 136.
136, I'm there.
Kindly come to paragraph 15.
15, yes.
Please note that the periods referred to in paragraph of the writ petitions are following periods. Lordships may kindly take the fourth period.
Fourth quarter, 84, 85 up to.
Then please note that the KMC had initiated proceedings for increase and or enhancement of the property tax by purported notice. And in light of the judgment of the division bench of the Calcutta, the KMC could increase the annual valuation of the said property up to the period of 3 years. That is to say, for the period commencing from 27 February 1996. So, my lord, 96 onwards, they have paid. We have increased and they have paid. The arrears in dispute, they have challenged by second writ petition because there is an amendment now to the Kolkata Municipal Corporation Act by which the retrospective effect has been given. Now, insofar as this 27 February 96 is concerned,
yes,
I had on the last occasion I had said that at least for this period, let them pay whatever the dues are. Your lordship said that you get a calculation.
Yes.
What is the exact amount?
Yes.
This is the calculation that I have given. Let him check up.
My lord, I will definitely come back after 2 weeks. My lord, kindly take the calculation which is being handed up to your lordship. My lord, lordship may kindly, my lord, take page 119 of the writ petition for once.
Yes.
And kindly come to, my lord, page 129 straight away. Well, instead of troubling your lordship with the entirety of the order, I will just take your lordship to the operative part of the order. What was required to be done and what has been done.
Yes.
My lord, your lordship will kindly take page 129.
Yes.
This is the first new paragraph. In those circumstances, this appeal is partly allowed by directing the respondent corporation to make a fresh assessment. But till date, whatever calculation they have given, fresh assessment proceedings had not been undertaken. A. In relation to the period covered by prayer B of the writ petition, on the basis of the observations made in this judgment within 8 weeks of the communication of the order, and to raise final bills on the appellant petitioner within a further period of so and so. So, my lord, first assessment is to be made. Your lordship, I did not even point it out to your lordship. This is so your lordship is aware. Then, my lord, only the bill or demand can be raised. This has not been done. Now, my lord, kindly take, my lord, the impugned notice.
If my learned friend wants to do the matter, then I
No,
request your lordship not to take it up because there are good grounds.
We'll do it.
We'll come back and fight it.
My lord, we will come back and fight it. Only one thing, my lord.
Yes.
In the meantime, my lord, they should not take any coercive measure. Because, my lord, we are paid from 2006-7.
Without fresh assessment,
My lord, I tell you, lordship, we are paid amount of in excess.
I'm not passing any interim order. Sir, I'm not passing any interim order. He's asking for an adjournment. Let it be next week. When is
After 18.
After 18th, my lord.
After 18 will be too long.
2 weeks time is needed.
No,
My lord, we have paid an amount of I'm sorry.
He's not coming to the court
Yes.
for 2 weeks.
I believe
My lord,
Mother has expired with some funeral.
But, my lord, in this case, I tell you, lordship, my lord, in this case, since we have challenged the amendment, I think, my lord, we have served notice upon the learned advocate general also.
That is the reason.
For the advocate general.
For the state.
For the state.
State and advocate general.
State.
They are appearing for the state. My lord, we have served notice upon the learned advocate general since the validity of this amendment act is under
He was
challenge.
there last time, I think.
No.
He's not representing the advocate general.
No.
I think he was representing the advocate general. That's what I remember. He said, I appear for the state as well as the advocate general.
As well as advocate general.
Yes,
We
that's
have
what
missed it.
I
That is
remember.
our fault.
You have instruction to that effect. I think he appears for both. That's what he
My
had
lord,
said.
your lordship will also kindly record that we have also given a calculation sheet.
I'm not recording anything.
Anything. Very good. Come back.
Let this matter be listed on the, at the request of the, State. whose mother has expired? Proxy counsel so-and-so states that Mr. Satyajit Talukdar
18.
has suffered a bereavement in the family. He has suffered a bereavement in the family. He requests for a short adjournment. Let this matter be listed on the, what date you're talking about? Give a date. 22nd.
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 Well, that will be just immediate, just 2 days prior to vacation, subject to correction.
That's okay.
Well, then very well, we'll come back.
Much obliged.
Item number 6.
I appear
My
for the
lord,
corporation.
before my learned friend start, on the last occasion, my lord, I have committed, my lord, to hand over, my lord, the reported judgment of various judgment I relied upon. This is the copy. If this honorable court direct me, I can indicate, my lord, the relevant paragraph. Only one judgment I have enclosed with this bunch of judgment, which on that particular date I did not produce. That is a statutory authority cannot do anything unless permitted by the law. Well known, my lord, everyone knows. Lordship, if directs me, I can, my lord, indicate the paragraph.
Yes, indicate the paragraph.
Kindly, my lord. The first judgment is 2012 3 WBLR, Calcutta 916. PS Group Realty Limited and another versus Kolkata Municipal Corporation.
Yes.
Here, my lord, 6, 16 and 19. And corporation cannot force me, my lord, to undertake either in a stamp paper or any other blank paper also. My lord, then, my lord, kindly come to page 12 of the bunch of judgment I have made pagination. Page 12, my lord, Asian Leather Limited versus Kolkata Municipal Corporation.
You have not shown
No,
this.
admittedly, if this honorable court kindly permit me, my lord, this is a well-known settled proposition of law. That is, a natural person has the capacity, paragraph 12, my lord, to do all lawful things unless his capacity has been curtailed by rule of law. It is equally fundamental principle that in case of a statutory corporation, it is just the other way. The corporation has no power to do anything unless those powers are conferred on it by the statute which creates it. Paragraph 12. Then, my lord, lordship, kindly come to my lord, page 34. I have done pagination, paragraph 27. This is relating to Shahu Jain Charitable Trust. Paragraph 26, 27. My lord, 573. The authority is not permitted to, my lord, do the valuation after 3 years. That is the statutory bar. Though, my lord, one division bench judgment is there in this field, my lord, I am not that referring that judgment. If my learned friend refers that judgment, I will distinguish it. Page 45. Since all the hearing are taken place ex parte, my lord, on the similar point, the honorable division bench was kind enough to decide the under certificate of posting and sounded a caution that it is not a proper service. Paragraph 16, 20, para 35, para 36.
You have filed your reply to the affidavit in opposition?
Yes, sir. That I have filed.
Argue the matter. Yes.
Yes.
We will finish.
Your lordship sees the prayers. The challenge is actually to the recovery proceedings.
Yes.
Prayer A and prayer B. Prayer A and prayer B at page 12 and 13. The challenge is to the recovery proceedings. As a collateral challenge, the assessment has been challenged in prayer C. This is the ground reality on the basis of which the writ petition has been moved before your lordship.
Yes.
Now, it is an admitted position that the building is G plus 4, 5-storied building, and it is at 7/1 Topshia Road.
Yes.
Now, my lord, the assessments has been made, then demand has been raised,
Yes.
and he had gone, he had paid, he had given an undertaking. Thereafter, he comes up before the court challenging the entire episode which had gone by.
Yes.
I am coming to the judgments. For the time being,
Your Lordship would kindly take paragraph 14 and the undertaking which he had given, which is at page 59. Paragraph 14 and page 59 has to be read together. But I am placing paragraph 14 first, then I'll take your Lordship to page 59.
Yes.
Your petitioner state
Yes.
that on 2011-24, when he gives the undertaking, the petitioner as a bona fide taxpayer went to the office of the concerned department for submitting two demand drafts amounting to 20,95,000 towards the payment of outstanding property tax in respect of the above referred assessee numbers. My lord, let us pause over here.
Yes.
Does it talk of any threat? Does it talk of he goes voluntarily with 20 lakhs of rupees in his hand to pay the tax? My lord, thing is coming that he knows there are dues, and he knows that these dues are to be liquidated, and he goes on his own to deposit these demand drafts.
Yes.
Why? Well, a prudent man will just not go to the office of the corporation with 20 lakhs in his hand to be deposited in the coffers of the corporation unless he himself is satisfied that this money has to be paid. Now, thereafter comes when the petitioner was verbally threatened by the official of the department that in view of the huge outstanding property tax against the 5 assessee numbers, the corporation authorities would issue distress warrant. So it is at the recovery stage, assessment done.
Yes.
The dues have been quantified. He knows the dues and it is in a huge amount. He produces the demand draft for liquidation of the dues.
Yes.
And thereafter turns around and says, I have been threatened. Now, my lord, asking a person that you have paid 20 lakhs, the balance is this much, what will you do? Then if I come out, well, sir, I have got a letter, I have given this and I am giving an undertaking to pay it. Will it turn to threatening? Will I ask a question to myself? And when does the retraction comes? That also I will show, my lord. Then my lord would kindly take this is one payment. The second payment has been made the very next day, that is on 21st of, sorry, I'm sorry.
Yes.
Well, it takes paragraph 15.
21st.
So if 20, there was a threat, there was a coercion, will that same person on 21st go and make further payment of 2 lakhs? I ask a question to myself. Does the story sought to be made out by the petitioner holds good? Only question is that I say that the dues were there. He is aware of the dues and he knows that the dues are high. So he goes and makes the payment. And on inquiry, what would be the fate of the balance amount? He comes out with the letter, says that I am giving an undertaking. Now, in this backdrop, 15, 14, and 15, your lordship would now take page 59. I am the owner of the above mentioned 5 number assessee in respect of the caption premises number having total outstanding property tax of so-and-so, including interest and penalty up to November 2024. Today, 2011-24, I have submitted 2 number demand drafts totaling so and so against the total outstanding due in respect of the 5 SSC numbers at the time of execution of distress warrant. Malad, naturally, Malad, if my dues are there, that is one of the procedure of recovery, and he is aware and he goes. Now, beside this, I hereby undertake to pay the rest of the amount in respect of the caption 5 number assessees against total outstanding property tax due by the end of December 2024 upon application under slab-wise graded waiver scheme. Corporation time to time floats waiver scheme. If you opt for that waiver scheme, certain amounts are, certain exemptions are given. Failing which KMC authority shall be free to take necessary action. Amalad has seen this is 20th, now the retraction. Your Lordship would kindly come to the retraction also. Retraction is at page 72. If I have threatened, it is, I have taken it on a gunpoint, this undertaking. Malad, police authorities are there. Nobody stopped him to go and lodge an FIR against the officials that yes, on the gunpoint I have been threatened and that undertaking has been taken. That's not the case. What is the case? Case is, your Lordship gets it at page 70. Here, the lawyer says that the person was threatened and that undertaking that I would be paying by December was taken. Your Lordship sees that on that, I'm showing page 71.
Yes.
The paragraph starts on 2011-24.
Yes.
When my client went to the office of the concerned office for submitting 2 demand drafts towards payment of the outstanding property tax in respect of the above referred RSC number, my client was forced by the officials.
Yes.
So what was done on 2011-2024 was sought to be undone on 10-12-24, almost after 20 days. Whether this retraction also is tenable in the eye of law. Now I'll be going to the judgments because these are the small facts. But before that, my lord, I want to my lord, I would be failing in my duty if I not bring this. I don't bring this to your lordship's notice. My lord, the entire building is illegal. There is no sanction plan from the brick number 1 to the last brick. And well, it's a very clear proposition. A man in the wrong end of the law cannot seek equitable relief from a court of equity. A man in the wrong end of the law cannot seek any relief from a court of equity, whatever is concerned, he has argued. Now, my lord, I'll straight away take your lord.
For an unauthorized property, how do you collect property tax?
My lord, so far as unauthorized property tax. Yes, my lord. My lord would kindly take section 400. It's not debarred.
KMC.
Page section 400.
KMC.
Of the KMC Act, your lordship takes subsection 2. Subsection 2 of 400.
Yes.
Yes. Yes. Malas has got subsection 2. The municipal commissioner may make an order under subsection 1, that is of demolition. Demolition, notwithstanding the fact assessment of such building has been made for the levy of property tax on land and building. Malad, as long the building stands, it enjoys civic amenities, civic service, and the property tax is only to defray that expense. So even if it is an illegal structure, as long it stands, I am entitled to impose tax on it. When it goes, my lord, my demand also goes. But as long it stands and enjoys the civic amenities, the assessment of that building will be made and the tax would be collected. Now, my lord, would kindly take, this is the short format of the demand and the recovery. And the other challenge to the assessment is a collateral challenge. Now, to challenge that demand, his case is, he first says he's on the undertaking. That undertaking could not have been taken and the undertaking is bad. Now, for that, he relies upon PS reality. Your lordship would kindly take PS reality. Yes, PS group.
Yes. That's it.
My lord, I am reading from SCC online, so I do not have the paragraphs as such. But if your lordship, at the very outset, if your lordship leaves 4 paragraphs, a paragraph starts, probably it would be 3 in your lordship. The printed copy what my learned friend has given. The petitioner submitted.
Yes.
The petitioner submitted an application under application dated September 23 before the competent authority of the respondent number 1 for mutation of the names of the petitioner 128 in the assessment book of the respondent number 1 by a communication, my lord marks this, by a communication dated September 2008, the respondent number 1 informed the petitioner 128 that the annual valuation of the premises was proposed as follows. The petitioner number 128 were further informed by the above communication to meet the respondent number 4 within 7 days from the date of receipt of the above letter with a declaration on non-judicial stamp paper of ₹10 to the effect that they were agreed to accept the above valuation, and failing which the respondent number 4 would process the case for hearing of the proposed valuation. The petitioner submitted a declaration on a stamp paper of 10 accepting the above assessment of the valuation of the said premises for the periods mentioned herein above. On September 25, 2008, supplementary bills were issued by the competent officer of the respondent number 1 on the basis of the aforesaid assessment of the annual valuation of the premises, and upon payment of those supplementary bills, the name of the petitioner number 1 to 8 were mutated in the assessment book. Now, my lord, thereafter,
yes,
this is the factual background. On these facts, subsequently the writ petition was filed.
Yes.
And the court ultimately decided this writ petition, saying that when there are provisions, notice has to go 184, proposal has to go over there, then you have to invite in objection under 186, the hearing officer has to assume jurisdiction under 187 and pass order under 188, and 189 is the appeal against the order if the person is aggrieved. But I ask a question to myself, what are these facts? He says, yes, reality will apply. Their corporation said that, yes, I am sending you, kindly give an undertaking on a 10 rupee stamp paper that you have agreed to our proposal. If you have agreed, done. And if you have not agreed, then we will take the normal course of assessment. Here it is not that case. Here, and it is at the stage of assessment. Here that stage is gone. Now we are in the recovery. That's the reason, my lord, I showed the prayer first. We are in the stage of recovery. When he goes, knowing fully well that this money has to be paid, he proceeds along with the undertaking in his pocket, goes with 20 lakhs and pays this month 20 lakhs. And when questioned about what would be the balance, he comes out with an undertaking. We have accepted it. And after 20 days, he retracts it. Whether this story sought to be made out from the bar is sustainable in the eye of law, particularly when the entire building is illegal. I'll come to that, why all this rigmarole is going on. Now, my lord, his second judgment is that of Shahu Joint Charitable Trust. The dispute in Shahu Joint, your lordship gets it at paragraph 11.
That matter just before you was
But
this.
I appeared when the matter was initially decided. I was there.
No,
This
that
matter-
item 5
Yes, I know.
pertains to.
I know. I have something more to say. When I deal with this, I'd be saying that also.
Yes.
My lord, 11, what was the dispute before the court?
Yes.
Dispute before the court is, in the instant writ petition, appellant writ petitioners have sought a declaration that the second proviso 179(2)(d) of the Kolkata Municipal Corporation Act is ultra vires to Article 14 of the Constitution of India. Furthermore, the assessment orders dated 16th November 99 for the assessment period 4th quarter 84-85, 3rd quarter 1991, 4th quarter 1991, up to 3rd quarter 96-97, 4th quarter 96-97, 4th quarter 99-2000 be quashed. So what was challenged are the assessments sought to be made. And what is section 179(2)(d)? Your lordship gets it at paragraph 13. First of all, a look at certain sections of Kolkata Municipal Corporation Act is necessary. First, we set out proviso to section 179(2)(d). That is the bone of contention. Provided, this proviso is the bone of contention, provided that further that the municipal commissioner may, on expiry of such period, revise the annual valuation of such land or building at any time. This any time is the catch.
Yes.
And such revised valuation shall take effect from the beginning of the quarter for which the annual valuation would have been revised under the clause. See, this any time, in terms of the court's observation, finding, it gives uncanalized. And today, my lord, I can assess or revise an assessment done 25 years back. Now, this any time has been read down by the Honorable Division Bench. How it has been read down? The Honorable Division Bench draws inspiration from section 573. Limitation, claim, demand is not the subject matter of dispute in Shahu Jain. Shahu Jain is on the day when you start the assessment to how far back you can stretch yourself retrospectively. That is the dispute. Now, my lord would kindly take paragraph 18. The proviso is very important, as I was submitting. It says that no proceedings for recovery of inter alia municipal tax shall be commenced. Well, this is the proviso of 573. After a lapse of 3 years from the date on which such sum became due, it is not assessment became due. It is the sum became due. When an already sum has been determined and it has fallen due, 573 says that you can only go, it has to be within 3 years, beyond that you cannot. Under the second proviso of subsection 2 of section 179 of the Act, the proviso to 573 would be rendered odious by giving annual valuation of the premises for an unlimited period of time, that any time. Theoretically, the tax would become due on the date of the revision made by the commissioner. But the real effect is that the person liable to pay tax for a property could be fastened by the commission with liability to pay tax otherwise not realizable long after the period of limitation. Then Malad would take paragraph 27, ultimately what the court says. We adopt the same procedure. The commissioner can only have the power to revise valuation, not make a demand.
Yes.
Not make a demand within a reasonable period of time. In the case of Santosh Kumar so-and-so, reported in so-and-so, the Supreme Court computed reasonable time in subject act to be 3 years. Then, in section 573, Kolkata Municipal Corporation Act, the corporation has the power to recover any sum by initiating proceedings within 3 years from the date such sum became due and payable. Therefore, on a proper interpretation of the proviso of 179D, and upon reading it down to save it from unconstitutionality, the period for which the valuation of a property can be raised must not be more than 3 years before the date of revising the order. So it is a authority, if at all, for revision of valuation, not making a demand of recovery. Why it will not happen? Why 573 will not come in the way? The answer to that is AIR 1998 Calcutta 345. It's quite interesting that Malad Justice S.B. Sinha in one paragraph put in the entire judgment in this matter, paragraph 4. And we find it very difficult to place it because some portions are relevant, some portion is might not be required in this case. At page 346, paragraph 4 starts. Now, this is an authority of limitation on recovery. The question of limitation in the recovery proceedings does not arise as the jural relationship between the parties continues. In any event, the limitation was saved by the reason of the interim order passed by this court. So far as the second writ petition, I do not want to trouble your lordship with this. Then my lord would just skip pages. Then at page 349, your lordship would find on the right hand side a paragraph starts.
There's no doubt.
There is no doubt that there exists no provision for limitation so far as the recovery proceedings are concerned. Mr. Banerjee, however, has relied upon Section 573 of the Act, which provides for recovery of certain dues and reads thus. Section 573. Recovery of certain dues of the corporation, save as otherwise provided in this Act, or rules or regulations made thereunder, any sum due to the corporation on account of any charge, cost, expense, fee, rate, or rent, or any other account under this Act, or the rules and regulations made thereunder, shall be recoverable from the person from whom such sum is due, as if it were a consolidated rate, provided that no proceeding for recovery of any such sum under this section shall be commenced after the lapse of 3 years from the date on which such sum becomes due. Then, Section 573 occurs in Part 3, Chapter 16, which deals with the power, procedure, offences, and penalties. 573 on a plain reading cannot have any application as regard payment and recovery of tax, interest, or penalty provided in Chapter 16 of the Act. It is now well settled principles of law that a due of a person reliable from should be, the spelling mistake probably there, realizable, I think it should be, reliable from another does not efface nor the claim of such person stands extinguished, even in a case where Limitation Act applies. In terms of the provisions of Limitation Act 1963, recovery of a sum by taking recourse to filing a suit becomes barred. Limitation Act 1963 cannot have any application in relation to the recovery of public dues unless a statutory provision exists. Therefore, Section 29 of the Limitation Act has been set out. Then, my lord, your lordship would see a paragraph which starts a special statute.
Yes.
A special statute may provide for limitation or may not. In the instant case, the proviso appended to section, it should be 573 of the Act, only provides for limitation. Section 573 cannot have any application in relation to the taxes, inasmuch as by reason thereof a legal fiction has been created. By creating a legal fiction, putative or imaginary state of affairs is treated to be a real state of affairs, although it is not. The wordings of a provision, particularly the words employed in a provision of restrictive statute, should be construed in such a manner so as to enable the court to give full effect thereto. The proviso appended to section 573, which makes out an exception, provides for a limitation as regard to the recovery of impost stated therein, which was to be recovered as a consolidated rate, meaning thereby such recoveries inter alia could be made in terms of provision of section 220. But if any limitation for recovery of any tax was to be provided, well, I put emphasis over there, provided for, the same should have been done by using a clear and unequivocal language by the legislature. In chapter 16 itself, recovery of tax is also an incidence of taxation. It is now well settled, well known, that there cannot be any intendment so far as the imposition of tax is concerned, and in that view of the matter, there cannot be any intendment so far as the recovery of tax is concerned, nor any presumption can be raised that upon expiry of a certain period, such taxes cannot be recovered. A provision for limitation can only be brought by a statute. Such a statute in certain cases may be statutes of repose, but the legislature in its wisdom may not make any provision. Therefore, thereafter, my lord, relies upon certain judgments. I do not want to trouble your lordship with that. Then, my lord, would kindly take page 351. I'm leaving the submission part.
We'll come back after lunch.
Continuing matter item number 6.
Lordship, if I, Mr. Mukherjee starts, may I file the judgments of item number 3?
যেটা হলো I was facing AIR 98 Calcutta 345. Now, the scope and ambit of 573.
Give me the judgment. Which one are you relying on?
AIR 98 Calcutta 345. I'm just.
Yes, yes.
My lord, I was placing that I submit.
This is for item number 3, Lordship.
Yes, yes, I got. Arpita Sarkar. Yes.
But I was from AIR 1998 Calcutta 345. Your lordship gets the scope and ambit of 573.
Yes.
It is a section which talks about limitation of 3 years in case of recovery. It is not a case of assessment.
Yes.
So it will apply in case of recovery. He is challenging recovery. Because at the outset I said from his prayers, so Shahu Jain is not the authority for him to place that, saying that Shahu Jain is on the 573 limitation on assessment. It's a separate thing, not on recovery. So 573 has. Shahu Jain has no application. This talks about recovery. And after explaining 573, court says that so far as the recovery of tax is concerned, that 3 years limitation will not apply. It's very clear. Now, my learned friend has also shown one judgment of Swapon Ghosh. But before I part away from this, I'll just tempted to place last paragraph over here. Your lordship comes to 351. On the left hand side bottom, your lordship gets the paragraph starts. It is relevant to note.
Yes.
It is relevant to note that Shobboshachi Mukherjee J in Karnani Properties versus Corporation of Calcutta, in a case where the rate bills were sent under certificate of posting, observed at pages 490 and 491, in view of the fact that it has been stated that the said rate bills have been sent under certificates of posting, and in view of the fact that the documents were offered for inspection, I am inclined to accept the version of the Corporation of Calcutta on this aspect. Furthermore, it appears to me that the question whether or not the rate bills had been sent or presented to the petitioner in this case raises a dispute of fact of such a nature which it would not be appropriate to decide in this application under 226 of the Constitution. Now, my lord, this judgment, what my learned friend has cited, Swapon Ghosh, your lordship takes it up. The dispute again over here was corporation completed an assessment. They say the Swapon Ghosh was alleging that it has been done ex parte. I had no notice of that. I produced from the corporation vault that these are the postal receipts by which it was sent to the post office. Court came to a finding, where is that you have sent it to the post office, but that he has received it, that has to be also shown. Otherwise, you are just presenting the documents to the post office, it has no value. Your lordship would kindly take paragraph 35 and 36 of Swapon
Ghosh.
Yes.
The explanation into section 184 of the KMC Act in effect watered down the aforesaid principle of natural justice, irrespective of actual service of notice of hearing. Service would be deemed to have been effected if the notice is sent through any mode of service of Indian Postal Service or in any other manner decided by KMC. The stand of the KMC is that the notice was made over to the personnel of the Indian Postal Service on July 27, 2011. This would appear from the report of the Assistant Assessor Collector submitted to the Assessor Collector, on the basis whereof the latter passed the order dated September 29, 15, holding that the notice of hearing was duly issued to the appellant and therefore no further hearing can be granted to him. However, not a scrap of paper has been disclosed by KMC showing that the notice was received by any personnel of the Indian Postal Service on July 27, 11 or on any other date. We had on more than one occasion requested Swenson Muller would leave to produce some material to substantiate KMC's contention that the notice of hearing scheduled to be held on so-and-so addressed to the appellant herein was made over to the Indian Postal Service and was unable to produce. My lord, I could not produce the other part of the document. I could produce that it has been given to the postal, but the other part of it could not be produced. That was the reason, and it was at the stage of assessment, not at the stage of recovery. Now, my lord, why I say it, why 573 will still not apply so far as the recovery part. Your lordship would kindly take this judgment reported in. Yes, it is reported. 2003 1 CHN page 380. This is the judgment of Nepal Chandra Kaur and others. But I straight away take your lordship to paragraph 7. After hearing the learned counsel for the parties and after going through the provisions contained in section 573 of the Act, I am of the view that the aforesaid section applies only to the cases of recovery of any charge, cost, expense, fee, rent, or any other account for which, thereafter the words are very important. No mode of recovery is provided for in the Act, and in such cases, such amount should be recoverable as if it were a consolidated rate, provided, of course, that no proceeding for recovery of any such sum by taking aid of section 573 would be commenced after a lapse of 3 years from the date on which such sum becomes due. So the court is very clear. If for any demand, there is no separate provision for recovery, then you can proceed under 573, but 573 has a limitation of 3 years. Now, my lord would kindly come to the Kolkata Municipal Corporation Act, section 214 onwards. This chapter 16 specifically deals
with recovery.
With the recovery. Various sections are there. How to recover. Then 220 distress. what my learned friends say, that he was threatened with this case, that they will be proceeding to distress the property. So there is a process of recovery. There are various provisions. It is my prerogative under which provision I proceed. Now, as because there is a process of recovery is there already in the Act for recovery of the tax, this 573 will not apply. That is my most respectful submission. Now, in Shahu Jain, with the deepest of humility and utmost respect, I submit. What did the Honorable, though it's not relevant for this case, what did the Honorable Division Bench did? Or limitation is the statute has to provide it. It is not there. The limitation of 573 was cut and pasted in 179(2). Again, Malad, with the deepest of respect, I submit, it was a sort of a legislation. And again, one more important thing I say, this 98 Calcutta, which I have just now placed, was placed before the division bench. I was there. I was there in that matter. While delivering the judgment, 98 Calcutta is not there. This is how, anyway, nothing here, nothing there, but this is the case of Shahu Jain. Again, my learned friend, Mr. Ford. So, your lordship sees it from any angle. A building, while asking certain questions, because that document what I have handed up today is not the part of my affidavit in opposition, for a simple reason. When the affidavit in opposition was being prepared, nobody had any inkling about this. Now, certain queries were there to the department. While that query was being sought to be satisfied, they stumbled across that. Now, the question is, if your lordship sees from any angle, a G+4-storied building, which is thoroughly illegal, is standing. Be that as it may, corporation will decide whether to keep it or to demolish it and how they will demolish it. Now, an assessment has been done, as I have shown, paragraph 14, 15, read with the undertaking. He is aware of the dues. He went voluntarily to pay the dues. And his case is that at that point of time, I was made to write that letter. If he was forced to write that letter, then basic minimum is one should go before the police authorities that I was supposed to write this, or the retraction should have come immediately on the next day. What happens over here? He goes on next day with another 2 lakhs of rupees.
On 21st.
Yes. And then in the month of December, almost 20 days thereafter, he comes out with this story of retraction and cooking up a story that I was forced. But what are the attending facts does not show that there was any force or coercion. So, my lord, this writ petition does not have any legs to stand upon, particularly to stall the recovery. My lord, your lordship would grant us liberty to proceed with the recovery in accordance with the law.
Yes.
Lord, in their affidavit in opposition,
Yes.
not in the four corner of the said pleading, my lord, they took this particular plea, my lord, today, which they have taken. Possibly, my lord, in order to avoid a question which was not comfortable for them in one front, an assessment front, they are trying to use on raising all these questions, my lord. I am not standing on the way so far building regulation of the Kolkata Municipal Corporation is concerned. It is their duty, mandatory duty in terms of the 29K. Is their failure. No man can take the advantage of their own failure. What is more, my lord, what they are making submission before this honorable court, without consulting their record, I don't know, my lord, whether a particular word is to be preceded before lie. My lord, I am indicating blatant lie should be, my lord, used or not. My lord, this is the sanctioned building plan of the particular house. I have brought it through WhatsApp, and my lord, the plan is there. And my lord, on the basis of plan, I have made construction of all these things. If lordship kindly, my lord, intend to examine this particular plan, lordship, my lord, 7/1. That being the situation. My lord, I have received it through WhatsApp. Right hand does not know what the left hand is doing. Left hand does not know what the right hand is doing. That being the situation, my lord.
Same
Now, my lord,
property, Mr. Mukherjee.
I have given that instruction from the department. I'll consult how it could be done.
ये दिखाना.
so my lord, only my lord to prejudice the honorable court, such type
Why
of my
should I
lord.
prejudice
Yes,
the
my lord,
court?
yes.
I said that is
And-
different issue.
my lord,
what
the
they
ex-
will do.
We are not
I do
getting
not
it.
know.
Yes, ex parte hearing is taken place without sending notice. Lordship kindly come to 214. My lord, if assessment has assumed finality.
If I may have a copy of this from my learned friend.
No, my lord, they are the custodian of all record. They should
Already
not
have.
prefer all this.
Say,
No,
I'm
they are the
not
custodian of
answering
record.
the assessment.
They are the,
We are
yes.
not getting into.
Very well.
Lordship, kindly see. My lord, the assessment was bad. Lordship, I have shown one particular inspection book where no signature is appearing. I have shown, my lord, in number of, my lord, period that was expertise. I have indicated, my lord, the deeming provision of service is not accepted. So far, the assessment part is concerned. Now, my lord, kindly come to, my lord, the realization process. I am drawing lordship attention, section 214. Lordship, kindly come. My lord, this is chapter 26.
214 years.
16.
16.
214, manner of recovery of taxes by presenting a bill, then, my lord, by serving a notice of demand, then, my lord, the other procedure. Kindly come to, my lord, 216, presentation of bill. The method of service and method of sending notice is identical. Lordship, kindly come to 216, explanation portion. A bill shall be deemed to be presented under this section if it is sent by post through any mode of service of Indian Postal Service or any mode as may be decided by the corporation to the person liable for payment of the amount included in the bill. And in such cases, the date borne on such mode shall be deemed to be the date of presentation of the bill to such person. They have enclosed certain documents of under certificate of posting. So, my lord, the presentation of bill is not in an appropriate manner. That is why I am relying the Shapun Ghosh matter. What is more, my lord, I intend to rely upon a judgment which is yet to be, my lord, reported. My lord, fortunately, my learned friend was there as the lawyer of the Kolkata Municipal Corporation. This is Shudeep Kushari. Lordship, kindly see. Paragraph 41. The question of par inquirium of the judgment of, my lord, that particular Shahu Jain was taken into consideration by the Honorable Court. Just I am reading, my lord, paragraph 41, page 38. Lordship, I am skipping, my lord. First paragraph, second paragraph, 573, quoted. Then, my lord, the last paragraph of paragraph 41, I am reading. The issue of revising the annual valuation of a property and consequently the property tax payable thereon and the issue of recovery of such tax may be different. However, we need not delve into the question issue in the present judgment. Hence, we make no observation as to whether or not the decision of the Sahujoin case is par incurium, not having considered the earlier division bench judgment of the Calcutta Municipal Corporation and Abdul Gajnabi Mullah. My lord, the passed by the Honorable Justice Shotobrata Sinha and companion justice as their lordship then were. Now, my lord, this Sahujoin went up to the Supreme Court, review everything. What prevented, my lord, the Kolkata Municipal Corporation to rely upon this particular celebrated judgment as far as the realization process is concerned of Abdul Gajnabi Mullah, I failed to understand. My lord, considering all these aspects, our humble submission before this, the corporation is not, my lord, enjoying a power, cannot be fettered in any manner whatsoever. This is judicial review. We are before this, my lord, the high prerogative read jurisdiction. Lordship, kindly consider my submission, and my lord, that being the situation. My lord, this is my humble submission. No notice, nothing of this sort, my lord. That being so.
Matter heard. Keep
Deeply.
it CAV. Make it CAV. File like this, brother.
Item number 7.
I am for the added respondent in this matter.
That's why I am appealing on the state respondent.
Lordship, in this matter, Mr. Shaunak Mukhopadhyay is appearing for the petition. Lordship is on his way.
On his way.
For the respondent number 18, Your Lordship.
We'll have it next week. We file your, have you filed your reply and all?
But there is no direction.
There is.
There is a direction for affidavits. No.
Let me see.
Lordship, my supplementary affidavit may be kept in record.
How can a supplementary be filed without the leave?
I'm sorry, my lord. I appeal for the petitioner. I mean, led by Mr. Mojumdar.
Mr.
Hello, my lab record is not aware whether there is a direction for filing affidavits. If there be any, my lord, the affidavit has not been done. If your lordship grants me the leave, I'll file an affidavit. But it has to go into the, your lordship has to decide on the basis of the affidavit.
Lordship, in that event, I don't mind my learned friend using an affidavit. Kindly extends the interim order. It was a contested matter.
For a limited period.
Long hearing, there was an interim order.
When was the when was the interim order granted?
But initially,
there was no, there is, as I understand,
Granted
there is
on
no direction for filing affidavit. Your lordship can hear out
23rd of December.
Huh? Check on direction.
No, direction for affidavit আছে কিনা? No, there is no.
No, there is no such direction. They are filing.
What is the matter about?
No, this is with regard to an order passed for cancellation of trade license after the respondent or corporation had already inspected and granted it more than a year back. Now, at various stages, there had been allegations made against us till not the honorable coordinate bench of this honorable court relegated the matter to the municipal commissioner to decide on the scope of the allegations. But all that the municipal commissioner found out was we had not uploaded the materials. So with the direction that certain materials or information were required to be uploaded, the order of the honorable court was complied with. Now comes another round of obviously set up by some other persons now who are interested in respect of a civil suit. They say that the trade license has to be cancelled because there is no change of user. Now, initially, there was an assembly house, which got closed. The cinema hall got closed down in 2020. There is a shop now being run.
Issue, sir. Come to the facts of the case. What is the issue? I don't know what cinema hall you're talking about. What is the issue? Give me the bird's eye view of the matter.
Please come to note first. Page
against an order passed by
80.
us, my lord, in terms of the duration of this also.
Please come.
Which was the previously question was at one point of time used as a cinema hall. Now they have purchased the property or some other part of the process where they have obtained the property. Now they have started for using it as well as in bazaar. These are different stalls and that is the reason that they have to make certain construction works by changing the cinema hall to that one of the marketplace. And that is the reason court directed as well that not to allow it carry on business unless all the provisions are complied. Initially, we were cancel the license because certain documents are not available. Then proceeding was initiated by us under section 400(1), subsection 1 and also 416. 416 had you also had the option to look into it. There is a change of the sanctioning for certain circumstances. Well, we consider it and we found that he did not apply to us for change of use of the 460 for cinema hall to bazaar. Now their order has been passed. That order has been challenged before the lordship right now, and specific provisions under the act itself that against such an order, the one has to prevail an appeal. Now the other round of litigation is there that the court said if the fire license is not there, the fire license which was used by the cinema hall, that can be utilized for the purpose of running the M-Bazaar. Therefore, if the fire license is not there, therefore there could be any occasion for allowing to run the market. But this is the position on each shop.
I mean, in 2023, I was granted this certificate of enlistment appearing at page 83. If your lordships will kindly peruse that document.
Page
83.
Who are these added respondents?
I am running a stall over
You're running a stall.
When there was a cinema hall, there was a soda seller. He is the complainant. The consortium is the developer who has till now failed to obtain interim orders in a civil suit, which is pending before this honorable court. Matter had traversed up to the honorable Supreme Court with certain observations. That of course I shall have to comply with the municipal laws, and thereafter the order of status quo remains in the civil suit. But there is a developer, there is an owner, there is a sublessee, and there is a lessee, there is a sublessee. Now, in 2023 November, the certificate of enlistment is issued by the corporation authorities. After due inspection, that there has been full compliance of the municipal laws insofar as running this business is concerned. But what was the premises about? No, this was a 1920 building, which at one point of time was being used as a cinema hall. After 2020 COVID, the cinema hall closed down. The cinema license has been surrendered to the authorities. Thereafter, we applied to the municipal authorities for running a garment shop there, a big garment shop on the ground floor of that building. This has been allowed, and in 2023 November, the certificate of enlistment was issued. Now, they have charged me revised property tax and bills and e-receipts on the basis of the same. These documents are appearing at pages 88 to 91 of the writ petition.
Yes. Yes, sir.
Now, there was notices being issued from the department. What about the change of use? Ultimately, the matter came up before a coordinate bench of this honorable court, and on 22nd of May 2024, an order was passed by her ladyship. Please come to page 150. 150 in the second volume. That's in the second volume.
Yes.
At 151. The officer in charge, Hare Street Police Station, has forwarded a report before this court signed on 14th May 2024, which mentions that fire license under the West Bengal Fire Services Act was granted to Metro Retail Private Limited, valid from so-and-so to so-and-so 2024. Learned advocate representing the corporation has relied upon the instruction forwarded by 3 of its engineers signed on 13th May 2024, which mentions that recent inspection revealed that ground floor of the premises number 39 Benting Street has been converted to shopping mall, which is running business in the name of M-Bazaar. It was observed that there is a 3-storied building which was previously identified as Paradise Cinema Hall, which is in the nature of assembly building. Presently, it is found that the ground floor of the building is converted to mercantile building. Notice under section 401 has been served upon the person responsible. Infringement statement has been prepared and placed before the concerned authority. No sanction plan has been accorded by the department for change in use of the subject premises. Learned advocate representing respondent number 19, who is running the garment shop, submits that his client has all the requisite licenses and permissions for running the said business. Report of the corporation suggests that no permission was granted by the corporation for change in use of the nature of the subject structure, as it has been insisted that all licenses and permissions have been issued for running the business. Accordingly, the Commissioner of Kolkata Municipal Corporation or his delegate is directed to grant an opportunity of hearing to all the necessary parties to ascertain whether the business is run in accordance with law or not. if the concerned party fails to produce the requisite documents for running the business from the subject premises, then steps shall be taken by the official respondent to stop the business forthwith. A decision shall be taken by positively within 30th June. Now, not with this order, not the authorities go into the question, and ultimately it crystallizes into an order of results in an order of 18 July 2024 at page 153. But I skip over the quoted portion of the order. I have just now read before your lordship not what the order direction of the Honorable Court was. Then please see the first subparagraph of that page. Pursuant to the order of 22nd May 24 of the Honorable High Court, Municipal Commissioner KMC passed an order on 4th June 2024 by delegating the undersigned to take hearing in this regard. Therefore, hearing was taken up 2 times on 14th June and 4th July, respectively by serving the notice to the interested parties, wherein firstly, parties were directed to submit their respective written statement with documents within 1 week before the manager license, and after accepting the same, license department and the building department will prepare a joint report and placed before the undersigned for further hearing. Secondly, respondent number 19 was directed to submit the entire photocopy of the original sublease dated 10/11/23 before the manager license. Thereafter, hearing was conducted and necessary order to be passed shortly. At the very outset of the hearing, representative for and on behalf of the petitioner appeared and verbally submits that the Paradise Cinema Hall at premises number so and so, presently being used as garment shop, by changing its nature of use and made constructions therein without obtaining any permission from KMC, and have not obtained any fire license and other permissions for running the garment shop, and the ground floor of the said premises has been converted to shopping mall under the name and style of M-Bazaar. For such infringement made by the respondent authority, he prays for to take steps as per the provisions of the Act. Learned advocate for the private respondent verbally submits that the building was always used for commercial purpose and the building is still being used for commercial purpose. He verbally submits that the sublessors so and so entered into a registered deed of sublease dated 10th November 23 with his client PrimeLink Tradecom LLP being the lessee herein, by subleased the land more fully described in Schedule A for the period of 30 years for running the commercial business commencing on and from 11/10/2012 and expiring on 30th September 2042. He further submits that PrimeLink is an associate concern of Metro Rail and the brand M-Bazaar is owned by Metro Rail. The said 2 entities are controlled and managed by a common managerial personnel as per direction of Additional Municipal Commissioner on 14 June 2024. He made a written submission on 21st June before the manager license along with all cogent documents wherein he prayed for allowing the Metro Rail to continue using the ground floor of the subject premises for running the garment store under the name and heading so and so, by rejecting the complaint of the petitioner. License department reported that as per their database, one certificate of enlistment has been taken online through KMC web portal on 30th November 2023. Now, that's the document at page 83 which I had referred to. In the name of so and so at ground floor, by Sanjay Saraf and others for the trade of seller of non-food items, ready-made garments, fabrics, sari and accessories, by uploading one proof of occupancy in the name of PrimeLink as sublessee of the said premises. They also submit that as per the declaration made by the applicant, the premises is a residential building, and as per the assessment register, the said premises is recorded as the nature of use as Theatre Paradise Cinema. As per the direction of the Additional Municipal Commissioner on 14 June 24, they also submitted their report on 12 July, wherein they stated that if the authority deserves proof of occupancy of the place of business, may be uploaded by the applicant as because there is a mismatch in proof of occupancy of the place of business. In view of above submission and verification, all the documents placed by the parties, hence it is ordered that as per observation of license department as observed above, the online certificate of enlistment issued in favor of Metro appears to be incompleted in respect of occupancy of the premises. However, applicant be given an opportunity to re-upload the said relevant document related to the proof of occupancy of the premises within 2 weeks from the date of issue of this order, failing which the license department is at liberty to take appropriate action as per rule. With this order, the matter stands disposed of. So, no real infraction found, only direction was you upload the occupancy position, which we did.
Where are you supposed to challenge this order? Where's the appeal of this order? Before the trial.
Building tribunal. Final order is there 177. This is
yes, please come to.
This is it's dead.
Yes.
177.
Yes, sir.
It's at 177. Please come to paragraph 2.
177.
177. The complainant raised objection to regularization and conversion of unauthorized illegal operation of a shopping mall or departmental store in violation of court order. Interim order has been passed on 9th August 24 requesting PR and complainant to furnish written submission along with relevant documents within 15 days. As stated by PR that this is not at all a shopping mall. Shopping mall means a large building or buildings consisting of a lot of stores, restaurant, etc., which is community and entertainment center. But in this case, part of cinema hall is presently used as garment shop. Height of existing building is 13.650 meters. Now, only false ceiling is provided in between the wide space previously used as cinema hall. Same renovation works has been taken in toilets, etc., including one internal partition wall. Width of abutting road is about 17 meters. As reported by department, an application has been received on 23rd November 23 for taking up some repairing works for plastering, coloring, etc. in the premises which are within the purview of Rule 3.2. No permission is required for taking up this type of repairing works. On 12th April 24, Prime Link applied for allowing change of nature of ground floor portion which was used as cinema hall at closed since 2016. Please take note of this. Closed since 2016. At present, using ready-made garment shop for sake of running of livelihood of the employees. Concerning executive engineer issued letter to PR to produce relevant documents in support of said change of use on 4/4/2024 and department issued notice under 416(5) of the Act. On reply, PR stated that the conversion of use is changed from assembly cinema hall to mercantile. Both are commercial in nature. PR praise for allow of the conversion on 28th of June 24. PR applied for obtaining fire safety recommendation on 4 June 2021. This has now been obtained not successfully. PR submitted consent for enlistment for financial year 24-25 and SWN department for 24-25. Fire license previously issued for shop dated 19 December 23. As informed by the PR, fire department inspected on 15 February 24 and finally on 5th September 2024 for issuance of no NOC for the entire building. This will be placed before resolution committee on 19 September 2024. For parking requirement, Rule 78 for assembly building, quote unquote, parking space is required for every 35 square meter of carpet area, and for mercantile building, for area 25 square meter, one parking space is required for every 35 square meter of carpet area. In the sanction plan of the year 1960, no parking space has been shown. PR agreed to book space in free parking space of KMC at least 6 numbers as there is no scope of parking space in the existing building. Representative of complainant stated that the property could not be used other than cinema hall as per lease agreement. PR and complainant both are requested to furnish documents or written submission within a period of 21 days. The complainant highlighted the registered deed of sublease dated 10th of November 23, which was executed by the lessee in the capacity of sublessor, wherefrom clause 4D may be looked into, wherein sublessee was given for usage of demised premises, which inter alia as follows. Usage of demised premises. To use the demised premises for distribution, exhibition and exploitation of feature films and for cinema business and other allied business as permitted under the head leases, after procuring necessary permissions as from the Municipal Corporation of Kolkata and other public body or authority as per applicable laws entirely at its own risk and costs, and the sublessors will not be liable for such actions of the sublessee. He also referred to lease deed granted under clause 4C, which may be read as follows. Entitle the lessee for use of the demised premises for his cinema business and other allied purposes by him and also by his associate and subsidiary companies wherein the lessee is directly involved. Wherefrom it is clear that the said lessee who was the sublessor in the said demised premises was allowed to use the said premises only for cinema business and other allied purposes by him and also by his associates and subsidiaries company wherein lessee is directly involved, but in this present situation, the existing person responsible is neither a subsidiary company nor associate of the sublessor. There is a clear violation of lease granted in the year 2012. He further submits that he has filed a civil suit bearing CS number so and so, wherein the PR preferred an appeal before the Honorable Division Bench, being APOT number so and so, that's Consortia Project Private Limited, but where my learned friend now seeks to intervene. Honorable Division Bench, with his order dated 21st August 2024, passed an order inter alia as follows. Till disposal of the interim application, the lessee will be able to carry out their business in the usual course without making any long-term changes to the structure, that is without making any capital expenditure. The appeal and the connected application are disposed of. Being agreed by the said order, the complainant preferred an appeal SLP before the Honorable Supreme Court, being SLP number so and so, that's Consortia Project Private Limited versus Mohit Lal Sil and others, wherein Honorable Supreme Court passed an order on 6 September 2024 inter alia as follows. In the meanwhile, the following portion of the impugned order shall remain stayed. Till disposal of the interim application, the lessee will be able to carry out their business in the usual course without making any long-term changes to the structure, that is, without making any capital investment. We make it clear that the pending application for interim relief before the learned single judge must proceed in accordance with law, notwithstanding the pendency of these special leave petitions. Wherefrom it is clear that the order passed by the division bench for allowing PR to carry out this business in the usual course had been totally stayed by the Honorable Supreme Court, and with a further direction to hear the matter by the Honorable Trial Court accordingly. In view of the said direction, the matter again came up for hearing on 21/10/24 before the Honorable Supreme Court, where operative part inter alia is as follows. The interim relief granted with the order of 6 September 24 shall continue to operate till further orders. However, this order will not prevent the learned single judge from deciding the prayer for interim relief which is pending before him. We make it clear that the proposed decision referred in the impugned order shall be placed before the learned single judge. In view of above, he prays that the PR has got no locus standi to run the said business at the said premises, and reliefs which he has prayed before the Honorable Trial Court in the said suit, which is pending before the Honorable Trial Court. It is quite clear that he has got no locus standi to run the said business at the said premises. On reply, PR produced the following documents in respect to the interim order. 3/4/2024. The division bench directed the sublessee would be entitled to make repair and renovation of the premises with approval of KMC and also be permitted to carry on existing business. 4/7/24. The division bench has directed that no modification or clarification were made on the order of 3rd April, as minor repair and renovation works was done by obtaining permission from KMC, and the business of the applicant shall exist subsequently. On 21/8/24, the division bench has permitted that the lessee will be able to carry out their business in the usual course without making any long-term changes to the structure. Thus, APOT are disposed of on the scheduled date of hearing. On 27/11/24, PR produced fire safety certificate in favor of the applicant, trade license. On the scheduled date of hearing on 27th November 24 at 12 noon, only PR attended. The complainant parties appeared at about 1 AM. But it should be maybe PM. But if it is 1 AM, I don't know. And produced written submission by Nitin Kumar Jain of Consortia Projects Private Limited, and submitted the order of the Honorable Division Bench dated 4 July 2024 mentioning a portion of order that, quote unquote, if by any decision or action duly taken under law, such business is not permitted, then it ceases to be an existing business. Similar, the other person, the developer was heard not in our absence. He appeared at 1 PM when the complainant, the person responsible was not at the hearing. And of the Honorable Supreme Court order of 6 September 24 mentioning that, in the meanwhile, the following portion of the impugned order shall remain stayed till disposal. That's a repetition. Representative of Bhagwan Das Jaiswal, shop owner, also filed a written submission. But he's probably that soda seller. Representative of Shankar Dubey, resident of nearby premises, submitted a copy of writ petition WPO number so and so, the matter of Shiv Shankar Dubey versus State of West Bengal, Department of West Bengal Fire and Fire Service, Fire Safety. It is to be noted that the existing order of Honorable Supreme Court dated 6 September 24 in respect of special leave to appeal, wherein previous order of Honorable Division Bench dated August 21/24 being stayed in respect of carried out of the PR's business in the usual course, and the matter has been referred to the single judge in respect of interim reliefs as prayed by the complainant in this case. Whereas, as per section 416(1)(d) of the KMC Act implements that no person shall, without any written permission of the municipal commissioner or otherwise, then in conformity with the conditions, if any, of such permission, convert or allow the conversion of a tenement under a particular occupancy or use group to a tenement under any other occupancy or use group. For such change as per section 416(2) of the KMC Act, unless necessary alterations have been made to the satisfaction of the municipal commissioner, and in accordance with the provisions of this Act or the rules and the regulations made thereunder, or of any other law in force for the time being, for which it may be noted that already notice under 416(5) has been issued in respect of the said premises by the building department, that as per prevailing system of KMC, change of use of any nature of a building, if done by any person or occupier or owner, to apply before the building department with relevant documents for such change of use along with appropriate plan of such change, with other statutory certificate for permissible for such changes. Thereafter, building department will examine and inspect the site with all documents and will give their appropriate decision of such change of use. In this respect, the application made by the applicant for change of use on the ground floor of the premises on 12th April 24 for conversion cinema hall into garment shop for running livelihood of the employees. Prior to that inspection application, concerned executive engineer already issued notice on under 416(5) on 4/4/2024, which includes stop forthwith of such unauthorized use of such change. That while going through the documents in respect of sublease dated 10/11/23 and main lease dated 11/10/2012, it indicates that the said premises only used for cinema business and other allied purposes by the lessee and also by his associate and subsidiary companies wherein the lessee is directly involved, wherein sublease dated 10/11/23 indicates that the said demised premises only used for distribution, exhibition and exploitation of feature films and for cinema business and other allied business as permitted under headless leases after procuring necessary permissions. Hence, from the above, it can be observed that the Honorable Supreme Court order dated 6 September 24 has stayed the portion of the order of 21st August 24 of the division bench, wherein allowing the PR for carrying out their business at the said premises simultaneously. Documents submitted by the parties which reflects that there is a violation or misuse of the said premises in respect of running of the business as granted by the lessor or owner in the main lease dated 11th of October 2012. In view of the above observation, it can be concluded that change of use as done by PR without appropriate permission from KMC authority tantamounts to violation, followed by the usage of the said permission as mentioned in the lease deeds dated 11th October 2012 and 10th November 2023, as stated above, for which said change of use is disallowed. So, Lord, he squarely goes into not the propriety or not the inter se relationship of the parties via the lease deeds, but which is a subject matter of a civil suit. That's number one. But may my learned senior.
Now, the basic issue which calls for consider what would really mean change of user. These are the Municipal Corporation Act and the order passed by the Special Officer Building. As the at all considered in the perspectives of the purpose of the municipal law, he has gone by the lease deed and the dispute between the parties arising out of the lease deed. Is that the delegation given to him by the commissioner? Municipal Commission delegated him to hear out whether the change of user would be permitted or not. And what is the change of user? There's a building which was used for the purpose of cinema hall. Now cinema hall has not been running. They are using the said building for the purpose of a garment shop. Basically, is there a structural change? Or change to the extent that the entire purpose of building becomes void? The law says, for instance, starts with that whether it's a human habitable building. You are using it for commercial purpose, which goes to the root of the matter. Now, I therefore would invite your Lordship's kind attention. Kindly takes up under section 416 of the Municipal Act.
Yes.
But the no person shall, without any written permission of the municipal commissioner or otherwise, can in conformity with the conditions, if any, of such permission, A, use or permit to be used for the purpose of human habitation any part of a building not originally erected or authorized to be used for such purpose. But this is the fundamental. That today you are taking permission as a residential quarter, then you are using as a commercial enterprise. That is the fundamental thing which regulates the building rules. Change or allow the change of the use of any building for any purpose other than that that's specified in the sanction under section 396. What are the sanction? That this building would be used for the purpose of running a cinema hall. Now, running of a cinema hall, the compulsion was that people will assemble over there. Is fire, safety, security. These are the basic considerations on which it was granted. Now, it is being used only for a shop. does the fundamentals of requirement of 396 is valid here?
Sir, you can't use a cinema hall for shops, can you?
Lord, per se, no. Lord, I am not inviting Lord, the court's Lord, attention to the question, what was the purpose? Lord, you have to give him Lord, purposive construction of the statute.
The purposive construction of the statute is if a building is there, you can't make alteration changes in the building. You cannot even use the building for the purposes which it is not enlisted for.
Yes. Now, here, that would not be, that is a literal interpretation.
Yes.
So that is the purposive construction would be.
This order, appealable order?
Yes. This order is not available according to me. Because Lord, I challenge this on.
Which is the section for that?
Lord, that's 416. 416 kindly come. Fine, yes. Well, my challenge is on the ground of perversity. The applicant. The municipal commissioner, first of all, my lord, municipal commissioner delegated him to hear the matter. Municipal did not delegate him to pass an order. There was no order by the municipal commissioner according to me as on date. The municipal commissioner may, if he deems fit, order that the unauthorized use be stopped forthwith. Provided that before making any such order, the municipal commissioner shall give a reasonable opportunity to the person affected to show cause why such order should not be made. Then, any person.
Why do you say this order is not appealable, sir? Why do you say?
First of all, my lord, I again go back to the root.
Yes.
That the municipal commissioner has to see
Yes.
that by using it as a garment shop, you are really basically changing the character of the building.
Oh, rightly or wrongly, whatever it is, an order has been passed. Why it is not appealable?
Because this order is not available because we are challenging on the ground of perversity.
That is great.
That logically sees the order. That's my point. That why should I go for appeal and waste time? The order which my learned friend has placed, I just will take the trouble to bring out some important portions for minus consideration. But yes, the kindly comes to the page 180. Down the middle, my lord, whereas as per section 416(1), my lord, which is to notice it. This is the quotation of the statute. Then for such change, as per section 416(2) of the KMC Act, unless necessary alterations have been made to the satisfaction of the municipal commissioner and in accordance with the provisions of this act or the rules and the regulations made thereunder, for any other law in force for the time being, for which it will be noted that already notice under section 416(5) of the Act has been issued in respect of the said premises by the building department. As per prevailing system of KMC, change of use of any nature of a building, if done by any person occupier so and so, to apply before the building department with relevant documents for change of use, along with the appropriate plan of such change with other statutory certificates for permissible for such change. Therefore, it inherently means that you are going to change the basic character or structure of the building, for which 416 would come in. Now, today I just give an example. This building is for courtroom. Now, tomorrow the court decides it will not be a courtroom, it will be office room. Do I need to have permission of the authorities?
The lease deed is very clear to the extent whatever is the usage.
That is biological going back to a lease deed.
We will go back to
for
the
which
it has to be seen. The lease deed has to be taken into consideration. Sir.
With deepest of respect, lease deed said this is a building for running a cinema house. Yes. Right. Now, cinema house is not being run there, but the structure of building remains as it is.
The structure of the building remains as it is.
It is below the.
You are right. You are a lessee, sub-lessee. You're a sub-lessee.
Yes. My right cannot go above the source. I am not on that. My point is simply that while I'm using this building for the purpose of running a garment shop, would that I again maybe at the risk of repetition, take the risk of fire hazard? The fire hazard which was necessary for safety under a running of a cinema house was much stricter. Am I changing the structure of the building? Am I really removing one wall No, the building remains as it is in the same structure. Change of user means really instead of assembly of many people for the purpose of cinema, now a shop they are running. I do not dispute that I have to take a permission. I don't say that I don't have permission. But how would they refuse the permission? You can very well say that for the purpose of running the garment shop, you have to take additional measures. Because these are regulatory, not prohibited. And if you are exercising the regulatory power, then you have to ensure that the purpose of use is not frustrated for, if I may say so, minor violations, if any. Now the business is being run, the license has been granted, fire department has given me sanction. Therefore, if I again go back to the question of the change of user and preferring an appeal on that, that will frustrate the entire thing. Municipality has not said as of date that because of using this for running a garment shop, the building structure becomes insecure. Yes. This is not also the case that you are using this cinema house for the purpose of essential use. My lord, will kindly consider this aspect of the matter. And preferring of appeal, my lord, would really lead us again, my lord, to wastage of time. Nobody knows.
Not really, Mr. Bhattacharya. It's not wastage of time at all. The tribunal comprises of people who are experts who sit there to decide these things better than the writ court.
No, I follow.
Better than the writ court.
But here, my lord, what would the tribunal decide? There is no change of structure.
The tribunal will decide whether the order which has been passed by them is correct or not, whether they have taken everything into consideration after hearing all the parties and seeing what all documents you have placed on record and on what basis they have passed this order will be adjudicated upon by the tribunal, sir.
No,
that is what the tribunal will do, better than the writ court.
But
that's my view and that's the order I'll pass. You can take it in appeal.
No, but I have no idea how much time the tribunal nowadays takes for the purpose of disposal of the matters.
Living in India, sir, we all know how much time every
Therefore,
tribunal takes.
therefore, we are before the
court takes.
We are before
that
the
can't be a ground.
No, that Lordship will also
Then
take.
you should open a garment store abroad.
No, Lordship will also take this into consideration, which I'm not really inviting this court to decide. What is this purpose of the change of user? Why did the statute not make it, and what is the consideration?
Yeah, I will not get into it. You file a separate writ petition where you challenge.
No, that's the challenge here.
The scope. Today, I'm looking into that order which has been passed under 416, which is an appealable order. So you take it before the tribunal.
Today, probably, my lord is thinking that it's better you go to the tribunal for the alternative remedy.
Yes.
But my challenge here is also that what is the scope of 416? Would the 416 come in such cases, in such manner?
That academic exercise can be done later.
But this is also a part of this petition.
That will not help you. The academic exercise will not help you. I will not grant any stay. Let them file their reply. You want to do that academic exercise, we can do it.
No, now without my shop is being allowed to run. Therefore, I have also I have not yet brought on record by affidavit, but they have mentioned in the shop. Kindly see.
Sir, you move before the tribunal. That is good for you.
Anyway, if your lordship so feels.
Yes, what are the objections?
But then this
So far as
interim order.
even after cancellation, they are very well going on doing business. So far as 460.
Who appears for the corporation? Mr. Ghosh. Yes, Mr. Ghosh. How are they going ahead with the?
Well, I have given the details. Apart from that, well, I have explained it. Biologically, section 390. When the building, then the category of building is mentioned.
Yes.
If the category, one category of building has been changed to another category.
Yes.
Only ground floor.
This is the change of category.
Only ground floor.
319.
390 helps me. Yes, I am thankful to Mr. Ghosh.
So I'm just pointing out, it helps you.
Yes.
Very good. The occupancy or dispute means the principal occupancy for which a building or part of the building is used or intended to be used. For the purpose of classification of the building according to occupancy.
Yes.
And occupancy. Now, D says, D, you also kindly come to 2D. It's a motion picture house. It's a assembly building. Now they are trying to change this to a mercantile building. Now you logically come to A. Next, a jet premises now. Now we are changing to jet premises. Section 416 you has seen. Then when from the cinema hall to jet premises, different cubicles have been made for running the one of the M-Bazaar. And therefore certain construction has to be made.
How did you allow those changes to take place? How did you allow those changes to take place? Why didn't you take action? How did you allow those changes?
We have not allowed.
Then what notice have you issued?
Your Lordship would kindly take page 93. Page 93, your Lordship kindly takes. I'll show that, what they are doing. They have made an application and going on demolishing and constructing. That is their own admission. Your Lordship kindly takes page 93.
Yes.
My Lord, the last paragraph. We are in the process of getting necessary approval.
Yes.
From you in this matter to change the nature of business into partial portion on ground of then cinema hall doing business of ready-made garment. Now, my Lord, in this connection, we would like to inform that the partial portion of the ground floor, which was used as cinema hall, at present using ready-made garment shop. Yes. Before the approval comes, the shop comes in, carrying on business. Even after cancellation, they are carrying on business.
That is for you to see, sir. If they are carrying on the business illegally, you shut it down.
Mr. Ghosh will answer to that. Now, my Lord, so far it has fallen from your Lordship, whether it is appealable or not, and whether an appeal is to be filed.
Yes.
Lord, if I submit a division bench judgment, decided on 26th of April 23, my learned senior friend Mr. Ghosh appeared. Here was the same Amdichi, sir. My Lord, you take page 2. The learned judge, page 2. The learned judge observed that the order passed under Section 401 KMC Act is an appealable order under subsection 3 of Section 400, and the order passed under Section 416 of the pertaining to the change of user, also an appealable order under 416(6). Learned judge disposed of the writ petition. Then, my Lord, we have heard learned counsel for the parties. There is no dispute that the order of the special officer, which was impugned before the learned single judge in the writ petition, is an appealable order. Statutory appeals have been provided for in section so and so and so and so. We are of the view that given the nature of the disputes between the parties, the statutory appeal will be a more efficacious remedy for the appellants herein, and all disputed facts are there, my Lord, and it has to be decided on evidence. The writ court is not well equipped to decide the factual disputes.
That I already said, Mr. Mukherjee, that he'll be better off in the tribunal than over here. Yes, sir. What do you want?
No, I'll
relegate you to the tribunal. If you want, I can dismiss it. You want, you can withdraw it.
My Lordship is so desires decided to send us back to the tribunal. It's okay, but kindly fix them the time schedule. Number one, and number two, my Lord.
I cannot burden the tribunal with a time schedule. I cannot. That will be unfair and against the orders passed by the Supreme Court in recent times. Absolutely against the orders passed by the Supreme Court. We are not there to run the board of any tribunal. A High Court is not sitting to run the board of any tribunal. They are at liberty, and it is expected that they will dispose of cases expeditiously.
Very well, then the court was pleased to pass an interim order that no coercive action in the meantime.
I am not giving you any interim orders.
Then what?
You are running it illegally. You keep running.
I am not running it illegally. I have due permission.
So that order will go. Let
that order go.
That order will go. And
that order I have been.
That order has to go, sir.
Which order? My lord is not challenging. My lord is
By
considering-
which you are running this, it's a single, it's this court's order. There's a
Yes.
stay, so that will go.
But in the meantime, what happened? The subsequent development has to be taken into consideration. The municipal corporation has upgraded it, saying the shop, office, and theatre. Can you see this? And for which they are taking the additional tax from me. This is the recent one, which I have to being if also once by an affidavit.
What is this?
This is the municipals recent revised rate of charge and survey. They have upgraded the shop room.
The taxation would be self-assessment taxation after 2017.
No, not on this.
What are you talking about?
But they have made a separate independent inspection, and then in their assessment book they have registered the shop. And for running a shop, I have to pay the higher tax.
Mr. Ghosh, how have you done this? How have you registered them as a shop? Why don't you cancel it?
It was initially done.
What steps have you taken to cancel it? And why you have not cancelled it? You are taking money.
On page 80 of the
Huh?
What a subsequent.
I don't know about the subsequent event, my lord. But
You can't blow hot and cold, Mr. Ghosh.
That's the kind of once it was done, then the court was directed, they will pass the final order. They didn't say that you cancel.
After you have passed the final order, you can.
That's why they are saying for the cancel, but I don't know whether they are going on because nowadays we are online or not paying.
That is the difficulty. All these permissions come online. Mr. Bhattacharya, it's very interesting.
Let me put it on affidavit, let them come and satisfy.
No, there is no question of affidavit. Mr.
No, it was updated. What's online?
No question of.
This is done by after proper inspection. Can you look at it?
They can absolutely do it. They are ready and capable of doing anything in life.
Really, I can't follow. How could the municipality having granted it, the honorable
All right.
without
Yes.
One line of section.
Yes.
Two persons that without any written permission
Yes.
of the municipal commissioner, otherwise the conformity to permission.
Yes.
Without written permission, they have to take permission first. So then they have to operate all these things.
that we taken the permission. Now it has been granted.
Where's the permission?
Can you see?
This is to run the shop. The payment which you have made.
Can you see? Can you see?
Anyway, I'm not getting into that. Take down. The petitioner has preferred the present writ petition challenging the order passed under section 416, subsection 6. Dated 4/12/2024. Since the order is an appealable order before the Municipal Building Tribunal, this court is not inclined to exercise its powers under Article 226 of the Constitution of India, and the petitioner is left free to approach the appropriate forum in accordance with law.
Deep lovely.
With the above direction, the present writ petition is dismissed.
My lord, pardon my impertinence. Your lordship kindly takes page 80. The corporation had taken appropriate page 80, annexure P4.
Yes.
Now, this has been going on the basis of this, they are going on.
All right, you take action, whatever you have to take.
Whatever stay and all is there, my lord would kindly vacate them. Much obliged. Great.
Everything is vacated.
Great.
All application disposed of.
Deep lovely. Carboi.
Geo disposed of. All interim orders stand vacated.
Item number 8, my lord, I am for the writ petition, your lordship. My lord, this matter, my lord, may take some time. If your lordship kindly please to take it up on next Thursday, my lord, because my lord, upon hearing me, my lord, on mentioning lordship, please to direct the matter to appear in the hearing within first 5 matters, my lord. So, my lord, it may take some time. If your lordship tells so, my lord, I can commence, my lord, but that's why, my lord, on next Thursday, if your lordship
I
kindly.
had a word with Mr. Joydeep Kaur.
Yes, he is leading.
He has certain difficulties.
No, that's, I'm not on that.
We'll have it on
My lord, only one thing, my lord.
next Thursday.
Next Thursday, my lord, may the matter retain its position because lordship categorically said that it should, my lord, may it retain its position, my lord. আর সকাল থেকে we had waited since morning.
Locked.
The rest of the matters, then we'll have it. Anybody here? 3:30 is.
Yes, that's why we said on 3:30, my lord.
Anybody wants to do it? I'm here.
Joseph to bole.
We'll have it next week.
Next week.
Law.
Yes.